These new microphones are crazy, right? That's unbelievable to my face. Anyhow, good afternoon. Welcome to the Appellate Division, First Department. We have oral arguments for today, October 21. So please ask for the time that you need to get out the salient points of your arguments. Please keep in mind that we have read your argument, we've read your briefs. We are fully familiar with your arguments. The red light is for you, not for us, so that if we do have additional questions, we will certainly put them to you. People v. Kevin Howes. 5 and 1 and 3. Matter of Shante F. v. Miles Gustave. Hello. 4, 1 and 4. Matter of Eric T. That matter is submitted. Solano versus American United Transportation. You have a cross appeal? Did you have a cross appeal? No. 4 and 1 and 4. Garanis v. New York City Department of Education. 525. Certain underwriters at Lloyd's versus BSF Corporation. Who are you? Co-respondent for the AIG insurers, who we think before on the 6 and 4 split. Okay, so 6 and 2, 5 and 5. People v. Anthony Gonzalez. There are two matters. 525. Law Office of Cyrus Jobin, versus Manhattan District Attorney's Office. 414. Kellerman versus Duplication Services. Appellant? How about the appellant? Do we have an appellant? No, we have two respondents. Yes. You are who? Who do you represent? And how much time are you requesting? 5 minutes. I'm sorry, who do you represent? And how much time are you requesting? 5 and 5. Fifth Avenue Partners v. Punch House Flatiron. Appellant? 523. Pena v. the City of New York. Appellant? Thank you. That matter is submitted. Moore v. Greystone Properties. That matter is submitted. Ramirez v. 255 West 108th Street Corporation.
Good afternoon, Your Honor. Plaintiff request 5 and 2, please.
525. De Silva v. Super P 57. Appellant? 5 and 2, 5 and 1. Madrid v. Mazar. That matter is submitted. Coast Marine Company versus Holland and Knight.
Good afternoon, Your Honor. Appellant request 8 and 2.
Appellee request 625. First case for argument, People v. Kevin Haas. Yes, you may proceed.
Good afternoon, Your Honors. My name is Brian First from the Center for Appellate Litigation, and I represent Kevin Haas. Before a court can dismiss a sworn juror over a defense objection, it must be obvious that they possess a disqualifying trait. The record here does not come close to proving that juror Antway obviously did not speak English well enough to execute his duties as a juror.
Counsel, even if we were to agree with you on that particular point, does the record reflect that on the issue of his consciousness, how he felt about being able to judge others, and whether or not that was a grossly disqualifying factor, is that reflected in the record? And second part of my question, would we be able to reach that, seeing as how the court did not use that as his determination?
Exactly, Your Honor, and that I think that is the answer to the question, is that the court here determined that this wasn't a significant issue enough to render him grossly unqualified, so this court couldn't decide this case on that basis.
But the statute talks about grossly unqualified, right?
Yes, Your Honor.
So in this instance, the judge stated that the juror was grossly unqualified because of the lack of understanding of English. So could we, I mean, based upon the record, could you look at the total record, the totality of the record, and say there were other issues which played into the juror also to be considered grossly unqualified? His statements concerning his religion, his statements concerning sympathy, possible sympathy from one party over the other. Could we take all of that into consideration and find that the court was justified in finding him to be grossly unqualified?
No, Your Honor, because the court explicitly found that that was not a sufficient basis to find him grossly unqualified. So to affirm on that basis would be a different grounds than the court actually held upon. And so this court, I think the only issue that is ripe for this court's review is whether his language ability was sufficient reason to find him grossly unqualified.
Was your consent required?
No, well, the reason that the grossly disqualified standard comes into play is because counsel did not consent, because counsel objected to this, Your Honor.
So during the colloquy with the juror, the court stated, these proceedings are being conducted obviously in English. You have any issue with respect to everything you've heard in this case, whether you could understand everything, or are you in some way impeded, both in the discussion now and the discussion now and the discussion earlier because of your language? And then the juror responds, because of language, sometimes it's difficult for me to understand it well in the tense. And then the court said, did you understand everything I said, or did you have any questions about whether you understood everything they said during jury selection? Some of it, I didn't understand it well. And the jury responded, you did not understand. And then there's further colloquy. Judge says, you did not understand. Juror says, yes, please. Court said, did you attribute that to language issues? Juror said, yes, please. The court then asked, what's your main language? He said, I speak English. What's your first language? He said, Chi. So given all of that, does it not appear that perhaps there was sufficient indication that the juror was grossly unqualified based upon his understanding or lack of understanding of the English language?
No, Your Honor. Well, first of all, there was overwhelming evidence in the record that the court never reconciled about his English fluency. The fact that he was a surgical nurse at Jacobi Hospital. He had been a nurse in the United States for 7 years. He was educated from elementary school through university in Ghana, which is all in English. So that was never even considered by the court. So that alone raises questions that don't make it obvious that he could not serve as a juror. But just looking at that colloquy alone, Your Honor, the only thing that the court asked him is, did you understand everything I said over the last 4 days? Did you understand everything that I said? He says that 4 times. Did you understand everything that I said? And the most that the juror ever says is that he missed some of what happened.
So the court said, and in this case, you have difficulty being able to say that you understand everything I said over the last 4 days. You had difficulty understanding. The juror said, yes, please. And then the court said, were there things that you missed? And the juror said, I missed some.
Exactly, Your Honor. And so that cannot possibly be the standard for finding a juror grossly unqualified, because that would apply to every single juror on the bench. In fact, the court here told all of the jurors, he said, listen, These are difficult legal concepts that people spend their entire lives trying to understand. So of course you didn't get it on the first time. Of course you didn't. But you will get it. I will continue to repeat it. By the end of the trial, you will get it. So the court's telling all these jurors that. So there's an expectation that all of the jurors in this case will have the grace to miss some of what the court said. And of course, we all understand that to be the case. But for Mr. Antwi, there's a double standard that's applied that because he missed some, he's grossly unqualified. So I think that here,
But when the juror says that he missed some, the court didn't undertake further inquiry to determine whether the I missed some refers to I didn't hear it versus I didn't understand the words that were spoken.
absolutely, Your Honor, that's exactly right. And you have to add on top of that, this was a COVID-era trial with strict safety protocols in place. We've cited dozens of instances in the record where the court, the prosecutor, defense counsel, jurors are saying, I can't hear what's going on.
That's not the issue. The issue is the language.
But as your colleague just stated, that the court never distinguished that problem, whether or not
Whether it was because of the acoustics and the plexiglass, et cetera, as opposed to his not understanding.
or just the legal jargon in general. So that really the court
Thank you. You
needed
do
to
have
inquire.
time on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. Mary McGarvey Depew for the people.
People, I'll start with the same question. If we were to find that the language on the grossly disqualified requirements were not there for the language portion, would we still be able to reach the issue of his consciousness, his conscience, his sympathy? Would we be able to reach that, seeing as how the court didn't use that as part of his ruling?
No, Your Honor, and the reason I state that is that below, the whole basis of the defense objection was not the arguments that the defendant makes now. Below, defendant objected to the fact that the court indicated in a sidebar conference that it was, it had determined that there wasn't a conscience issue, and even on the record, he had explained to the defendant that he, especially with the heightened standard of 270-35 regarding a sworn juror, it was going to be difficult for him to reach that standard. And the court had determined that it was going to, based upon what it had heard and observed from this juror, that it was going to focus on the issue of whether this juror could adequately understand English.
Counsel, before that sidebar, what evidence is there in the record that this juror had any issues with the English language?
Before that side.
Before the sidebar, I want you to point to me in the record the indication or anything that would indicate to the judge or anyone else that's reading the record that this juror had a problem with the English language.
Yes, Your Honor. There are several instances before this sidebar occurs, and really what was compelling to the court and the court considered was the fact that time and time again the court had asked all the prospective jurors multiple times whether they had any issues they needed to raise to the court, the importance of being a fair and impartial juror.
That's
But
not getting.
we're not speaking of the other jurors. We're concerned with this juror. So
Who
as
had
my
been-
colleague stated, where in the record does it show that this juror was grossly unqualified based upon a lack of proficiency in English?
And that would have to be after the jury is seated because he's now a sworn juror.
Right.
Okay, so perhaps I misunderstood the question. The court considered the fact that this juror did not understand or sat idly by all the times the court asked.
No, you're not understanding. Where in the record does it show, right, that the juror lacked proficiency in English in terms of questions asked by the judge? I read some of the colloquy. So how does that show that this juror was not proficient in English, given the fact, well, answer that question.
It really does come down to that when the court has the opportunity to have that one-on-one discussion with the juror over the course of 20 to 30 minutes where he's able to observe the juror. I mean, one thing we can't tell from this cold record is whether or not there were any pauses, how long it took the juror to answer.
Up to this
So
point,
counsel,
I'm sorry. Up until this point, counsel, the juror had, as far as I could tell, satisfactorily answered every question posed to him by the judge and by the parties. He answered questions with regards to what he does for a living, registered nurse, surgical unit at Jacobi Hospital, right? Answered questions about his spouse, about what his spouse did for a living, the children that he had, where he's from. There's nothing to indicate on this record that this juror did not have a mastery or was proficient in the English language. I want you to point to me to a point in the record where that is not so.
Well, Your Honor, one place it is indicative is during the voir dire examination conducted by defense counsel, where
Wait,
I'm gonna-
he's already a sworn juror. So we're talking, in terms of the grossly unqualified, it's after he has been seated as a sworn juror. So voir dire by the defense attorney doesn't matter.
Well, I was just trying to answer Your Honor's question as to where it was on the record. I think a fair argument could be made that he did use that word repossession in terms of the voir dire, but it all becomes clear to the court afterwards when the court is having this colloquy and he's observing this juror struggle to answer and understand.
So, counsel,
The juror admits
I'm going to.
So, counsel, just said, Justice Gonzalez.
Yeah, let me dwell on one particular paragraph before the conference at the bench, where the court says, and if you felt sorry for the complainant who got shot, but you don't think that the defendant was proven to have done this, would you find the defendant not guilty even though you felt sorry for the complainant? And the juror says, can you please repeat that one again because I didn't understand it well? And then the judge says, counsels, may I see you at the side? So that raised a lot of questions for me in the sense that I didn't understand the question either that was posed by the court. The court later on goes to say that he has a suspicion, a strong suspicion, that juror number 12 was not in fact absolutely fluent. Would you agree that that is not a proper standard?
But the court over several times on the record cited to 270-35 and the grossly unqualified standard. The court repeatedly stated that it was aware it was a much higher standard to be utilized when you're dealing with the potential discharge of a sworn juror, and the court conducted a thorough and probing inquiry of this juror. The court spent a lot of time watching this juror struggle to answer his questions and hearing
I didn't
this
see
juror
this.
admit,
I guess what's
understand."
happening, counsel, is that, I mean, I don't see the struggle. I understand that his first language was Ghanaian, she, and his second language was English. But as a surgical nurse, almost by definition, he would have to be highly proficient.
Let me just say, he stated to the judge that his first language was actually English. That's what, when questioned, he stated his first language was English. That was his first language.
Right, but the court also had the opportunity to observe that once this
But
juror was-
I think the problem perhaps is when you are discharging a sworn juror as grossly unqualified, you must make a complete record as to the basis for your determination. And you are referring to body language, how the juror responded to the questions, the fact that the judge was able to observe the juror, et cetera. And that's all well and good, and that's proper. But here, we don't have any of this in the record. The judge does not say, I'm discharging juror number 12 as grossly unqualified because X, Y, and Z, I observed him, and I find that he's not proficient in the English language.
But the court said, I observed this juror had struggled to answer my questions. I observed this juror admit that he didn't understand.
But that's not what's reflected in the record when it comes to the issue of language, though.
But he did talk about, the court did talk about the fact that before the court was not aware that this juror was struggling to understand.
I think maybe where the disconnect is coming into play is that there was a whole a sidebar conversation that wasn't then put on the record. Right? So what we're looking at, the black and white words on the page, the black words on the white page, what we're looking at is that what does it say? And just based upon those words, the probing inquiry on the language issue might be lacking.
The other thing is, do we take into consideration, or should we take into consideration, the juror's background, educational background, the fact that the juror stated that English was his first language, the fact that he did attend school for nursing, the fact that he was a nurse. Do we take any of that into consideration? His educational background, and fact that the education, the courses that he took were in English?
I would just first like to answer your colleague's question. If you look at transcript 4, pages 59 to 61, that is where the court explains the basis for a decision. And turning to your question, Your Honor, no, the court cannot, because none of this is preserved for review. Below, defense counsel merely...
No, I'm saying, should the court not have taken that into consideration? Not us. Should the court not have taken that into consideration? Doesn't that play into the issue as to whether the juror was proficient in English or not?
I think the court has to be guided first and foremost by its own observations and this juror's ability to answer his questions. Because the fact of the matter is that this juror may be very proficient.
Counsel, point to me in the record the juror's inability to answer the judge's question.
Based upon their lack of proficiency or lack of knowledge of English.
Well, I would note that there are several times in answering the judge's question, instead of simply answering yes, he answered yes, please, which is an inappropriate answer. And he
Instead
Why?
of saying yes, yes, please,
As opposed-
indicates...
I'm sorry, what?
You're arguing to us that instead of saying yes, that the juror says yes, please, that's an inappropriate response, that indicates that there's a lack of proficiency in English?
Yes.
Oh, wow.
Could that have been cultural, counsel?
I'm sorry.
Could that yes, please, be a cultural way of answering a question? Being that he's from Ghana, maybe that's a cultural way of them answering.
Right.
You know, being respectful.
And then it would follow that if in fact we have these interpretations, wouldn't it have been better for the trial court then to say, what do you mean by yes, please? Follow up with certain questions to then maybe establish this lack of proficiency, as opposed to us sitting here guessing and filling in the blanks in the transcript.
Thank you very much.
Your Honors, I largely agree with everything that's been said.
Yes, so do you have anything further?
I do not have anything
Thank
further,
you.
Your Honor. Thank you.
Shante F. versus Miles Gustave. Yes, you may proceed.
May it please the court, Maham Shabir for the appellant Shante F. This case is not about whether Ms. F committed maltreatment, but about whether her name should show up when potential employers search it against the SCR, potentially affecting opportunities for Ms. F's employment. The ALJ below incorrectly found that the SCR report against her from January of 2020 was reasonably related to employment in childcare. The report should be sealed because all of the relevant factors in OCFS's policy guidelines weigh in favor of sealing it. I would like to point your attention to 4 aspects of the record with regard to the factors. First, the record contained no evidence of serious physical, mental, or emotional injury or harmful effect to DS. Second, the report came in as a result of a minor incident. Ms. F scolded DS after DS's playing around caused freshly laundered clothes to fall into a puddle. After DS ran away, Ms. F immediately called the police, and DS was found within a short period of time.
Counsel, would you agree that the 2 accounts as to what happened at the laundromat and elsewhere were so different that it really boiled down to a question of credibility, and that the court exercised its discretion in that, not the court, excuse me, OCFS
Yes.
exercised its discretion accordingly?
Your Honor, I would agree that there are differences in the accounts, but there are also similarities in the accounts.
Well, your client did not deny that she did become angry with the child, that she became volatile with the child, and that the child ultimately ran away. She never denied that, right?
No, Judge.
Right, so she admitted to that in terms of she took issue with perhaps some of the statements that the child made as to what she said. But she admitted that the ALJ based his or her decision on the issue as to the imbibing or use of marijuana, more so smoking, and the fact that smoking around a child, and in this instance, she wanted to either foster or adopt, or I guess in a daycare with children, and your client refused or stated that she would not discontinue the use of marijuana or smoking, despite the fact that it can be hazardous to other individuals. And that was the basis for the ALJ's determination, right?
Yes, Your Honor, you are right in saying that, and I would submit that the ALJ's repeatedly bringing up the presence of random men in the house was inappropriate.
But again, that wasn't the basis for the ALJ's determination.
Your Honor,
The main factor for the ALJ, and I thought that in terms of the report and the recommendation, was the smoking. And the fact that your client, again, stated that she was going to continue to smoke and she did not accept the fact that smoking, caused her daughter to cough and would cause children perhaps to cough and, respiratory issues, et cetera.
yes, Judge, but there is no evidence in the record that DS was affected by the smoke. There's no evidence of her developing asthma.
I thought there was record evidence indicating that the smoke caused her to choke.
Right. Diaz stated that the smoke caused her to choke, caused her to constantly cough.
Judge, the record actually states that DS told CPS that the smoke caused her to cough all the time. That could be just a way of speaking for a 9-year-old to say that, my mom smokes and it causes me to cough all the time. But aside from that, there is no evidence that there was harmful continued effect on DS, that she had developed asthma or any other medical problems for which assistance was sought by ACS or DS.
You do have time on rebuttal.
Thank you.
Good afternoon, and may it please the court, Jillian Barna for the state respondent.
Counsel, assuming that the only harm that's in the record to the child is that the child was coughed, is that sufficient?
Your Honor, the determination by the ALJ that maltreatment occurred here is not being challenged, and the basis for the ALJ's determination that the maltreatment is relevant and reasonably related to child care activities was really about petitioner's unwillingness to take accountability for her actions, to acknowledge the seriousness of her conduct, or to acknowledge the effects that her conduct had on her child. And her child said that the incident that occurred in January caused her to fear that her mother was going to hit her, and that she feared for her life. She ran away and remained on the street unsupervised for upwards of 30 minutes. And then we have this issue of the marijuana use in the house in the presence of the child, which the child said is causing her to cough all the time, which ultimately is harmful. And
Is it relevant at all that in June 2022, the petitioner was granted sole residential custody and joint legal custody of DS?
Your Honor, that's certainly a factor that the ALJ may consider, and the ALJ expressly acknowledged in the decision that petitioner had entered that order into evidence, so it clearly was considered. But the ALJ clearly felt that other factors in OCFS's guidelines weighed the other way, and it is.
So petitioner's application was basically to seal the record with a determination that it was unfounded. Is that correct?
Correct.
So is there anything to support that it was unfounded? Was there ever a determination made that it was that the allegations were unfounded?
No, Your Honor. The ALJ found petitioner to be incredible and credited the statements that the child had made to ACS.
And there was corroboration?
There was corroboration. The initial report came to the SCR because a neighbor had reported that, and the ACS also spoke with various individuals at the child's school who sort of discussed petitioner's erratic behavior and oftentimes inappropriate behavior. And when petitioner testified at the hearing, The AOJ engaged with her, asked follow-up questions, and petitioner was really unwilling to acknowledge that what she had done was serious and that it had caused her child harm.
So the petitioner was the one who actually called 911 to report that the child had run away.
That's correct.
And she, at some point in time, refused to allow ACS into the apartment?
That's also correct. Yes, petitioner did acknowledge that during her testimony at the hearing. Additionally, it is clear that the AOJ properly considered the guideline factors. It's evident from the decision itself where two factors that the AOJ clearly felt were particularly salient here were discussed. Additionally, the AOJ explicitly acknowledged that he considered all factors. Social Services Law 422 8C2 only requires that an AOJ base a decision on guidelines that OCFS itself promulgates. And in turn, those guidelines provide 11 factors to consider, but there's no mention that every factor needs to be explicitly discussed or that all factors are to be given equal weight. In fact, this court has said that it is up to the AOJ to determine what weight to give each individual
Was
factor.
the prior indicated report concerning the sibling considered at all?
The AOJ did not expressly acknowledge that report, but it was in the record before the AOJ.
Thank you.
Thank you.
Your Honors, my colleague across the bench just said that the main issue was that Ms. F did not express contrition for her actions. She was not sorry about what she did. But that is not a factor that OCFS policy guidelines require or ask for. What the factors ask for is whether the parent would behave differently if the same thing happened again. And I would submit that the record contains evidence of Ms. F's growth as a parent as a result of the incident. And that evidence would be in the form of DS saying eventually after some time that she would like to go back into the care of her mother, that a family court saw it fit to grant Ms. F sole residential in the majority of the legal custody to DS, that DS was doing well academically at the time of the hearing, and that there were no further reports. She had shown that she had progressed in her relationship with DS from when the report came in January of 2020.
Thank you. Thank you both. Solano v. American United Transportation. Yes, you may proceed.
Good afternoon, Your Honors. May it please the court, Jack Lockwood for the defendant or plaintiff appellant. Defendant failed to establish its initial burden on lack of causation. Defendant's own submissions included a report from plaintiff's treating physician from February 2019. This is shortly after the November 2018 car accident. That report found restricted range of motion in the lumbar spine with disc bulges. The doctor opined that those injuries were caused by the subject accident. That's at 380, 383 in the record. Defendants also submitted a report from Dr. Baines, who conducted an IME in February 2023. He concluded that there were no restrictions on plaintiff's neck, back, or knees. However, he did opine that plaintiff sustained cervical, thoracic, and lumbar, quote, strains and knee strains, although these were, he concluded these were all resolved. However, he concluded that those strains were caused by the November 2018 accident. In light of these submissions, which were submitted by defendants in support of their motion, they failed to establish their initial burden on causation.
So plaintiff ceased all treatment for her injuries after November 17, 2020. Is that correct?
It was after She had a right knee surgery in November 2020, and then
Right.
after that,
And so after that, there was no further treatment for her injuries, is that
that's
correct?
correct, Your Honor.
Was there anything in the record supplied by plaintiff as to why she ceased treatment?
Yes, Your Honor. First, I would just say that the burden did not shift in light of the fact that defendants failed to sustain their prima facie burden on causation. However, plaintiff did submit an affidavit in which she said that she had been treating for almost about 2 years after the accident. She took a short break while she was pregnant with her child. She continued resuming therapy after that. She was going 3 days a week, acupuncture, chiropractor, cold therapy. Her doctor told her that she might just have to live with the pain. And in light of the fact that she wasn't feeling
I'm sorry.
improvement.
So this would go to the issue of permanent consequential limitation, right? In terms of the continued treatment.
In terms of the continuous treatment, yes, Your Honor.
And so you're stating that that the record there is in the record indication that she continued some type of treatment? I thought that in the medical records stated that although her doctors had stated that she recommended that she continue treatment, that she did not do so.
Her doctor, she testified that her treating physician, don't have his name right in front of me, who was treating her for her spine and neck injuries, Dr. Belena, told her that her injuries to her spine and neck, she might just have to live with the pain, and that the physical therapy and that she was undergoing might not be able to help her. And
The doctors did recommend that she continue treatment, right?
The doctor said that they did recommend that she continue treatment.
Sorry, did or did not?
The doctor did
Did.
recommend that she continue treatment with the caveat, however, that it might not ameliorate her pain, and she
Might not, but it might.
might not, but it might. And she
Right.
continued to do it, and she did not get the results that she wanted, and so she testified that it was not helping her with her pain. And in light of her doctor not telling her that it was going to help her with ameliorate if she continued, that she discontinued it at that time.
Thank you.
Thank you.
Good afternoon, Your Honors. Matthew McDonough for the respondent. The trial court did not err in granting our summary judgment motion.
Counsel, on the issue of significant limitation in the use of the right shoulder, how did defendants meet their prima facie burden?
With regard to the shoulder injury, plaintiff stopped treatment so initially plaintiff stopped treatment in October 20.
But that goes to permanence. We're talking about significant limitation. How did you meet your burden on that issue?
We met our burden on that issue by pointing out the subsequent injuries that she occurred. First of all, she was involved in a 2023 motor vehicle accident that plaintiff did not include in their motion for summary judgment or even mention it, despite it being mentioned.
Did your expert offer any opinion or even examine that particular body part?
I don't have the record in front of me right now, but I'm unsure about the right shoulder injury. She did also suffer a subsequent injury when she was assaulted as a mail carrier, where she sustained injuries to both her neck and back. Both of these subsequent injuries, along with her pre-existing ones, break the chain of causation in this accident, coupled with her continued gaps in treatment. From 2019 to 2020, she stopped conservative care, including chiropractic and massage therapy, for pregnancy. The knee injury was related to the pregnancy as opined by the doctor, and she was recommended for surgery based on her pregnancy. With regard to her neck and back, like I said, she suffered 2 separate subsequent injuries to both of those body parts.
So counsel, if we were to agree with you that permanent consequential limitation of use is perhaps a weaker argument that the plaintiff is making, what would you say about the significant limitation of use?
With regard to significant limitation of use, plaintiff went back to work 1 week after the accident. She resumed her daily living activities, and by 2022, she was going on vacation with her family.
So the fact that she went back to work 1 week after the accident, that in and of itself proves that she did not sustain any significant limitation of use?
No, I think not alone, but when you couple it with the gaps in treatment, along with the subsequent injuries, I believe it does.
Now, we have to take into consideration that she's not only claiming injuries to her cervical spine, her lumbar spine, also the shoulder and the knee, correct?
Yes.
So those are different aspects of injury to her body, correct?
Yes.
So she could be working, but still be feeling pain to a particular part of her body, which could be significant, although maybe, she's just, like she said, working through the pain, because that's what she said. That she was working, and she was taking more frequent breaks, and she was taking more pain medication. She said that. She testified to that. Isn't that possible for someone to do that?
I believe it is possible for somebody to continue their job.
So then you need a doctor to say whether or not those specific complaints of the plaintiff to those parts of the body, first of all, whether the injury is there or not, as established by objective testing, whether that be an MRI, an X-ray, or some range of motion limitation, and subjective, what the plaintiff says he or she feels, correct?
Yes, Your Honor.
And this was established by plaintiff's doctors because they all said that she sustained injuries to those specific parts of the body and that she had reduced ranges of motion, didn't they?
Yes, her doctors did state that.
And that these were all causally related to the accident. Did they say that?
Yes.
So doesn't that raise an issue of fact?
It may raise an issue of fact that there is some differences in the expert opinions, but I would like to point out that the affirmation submitted by the plaintiff, by the doctors, were more than 4 years after the initial accident and the treatment, and they were used only to oppose the motion for summary judgment.
Didn't we see an affirmation there from her treating orthopedist?
I believe there was one from her pain management doctor. There's 2 radiologists, and the other doctor, I'm not sure.
From the surgeon that did the lateral and medial meniscal tear repairs.
Yeah, with regard to the knee injury, that doctor, though, did state that it was related to the pregnancy, and the plaintiff also testified that it was related to the
Did we see an affirmation there from Dr. Bellini, what's her name?
Dr. Bellini, or yeah.
Yes. And that doctor causally related her injuries to the accident.
Correct, but that doctor's affirmation was submitted 4 years after.
But he was her treating doctor, wasn't he?
Yes, to my knowledge, Dr. Bellini was her treating doctor.
Thank you.
Your Honors, with respect to the knee injuries, she was seen shortly after the accident by her treating physician, Dr. Capiola, I think. He recommended her for right knee surgery at the initial consultation. That was confirmed by an MRI. The pregnancy, of course, increased her pain in her knee, and plaintiff's treating physicians opined that it was causally related to the accident. Unless Your Honors have any further questions, I'll rely on her brief.
Thank you. Thank you.
Thank you,
both.
Your Honors.
Moranis v. New York City Department of Education. Yes, you may proceed.
Good afternoon. My name is Brian Glass. I'm here for Petitioner Katina Garanis, who's to the left. This court over the last 15 years has looked at a lot of these teacher termination cases of tenured teachers in New York City, and has shown a willingness to look at the proportionality and fairness of the results. And
Why is the penalty of termination disproportionate in this case?
I think because here we have a situation where someone was basically at a protest and was caught on camera for 58 seconds, and no one had an issue with this teacher before that at all. She had
What about
six-
the students? What about the students in her class? Let's take it from the early part of 2020. Some of them complained about certain behavior that she had in the class with respect to these students who were Jewish and Asian and Muslim.
I don't believe that's quite accurate. I think those only came about after the incident in July 2020. What they did, they went back and started asking students to go backwards. If you were going to ask what happened after the fact, if you put her back in the classroom and you had these series of incidents, that would be some sign of progressive discipline.
So you're saying that we shouldn't consider things that happened before the protest, the video incident?
Well, they weren't issues at all before the incident, and when they were starting to ask questions about these things, these were kids. If you look at what the hearing officer found, he dismissed most of those charges. I mean, very few of those charges sustained. There was allegations that she was, told kids to practice their Muslim religion in front of them. He dismissed that charge. There's something about a Jewish student. She actually teaches at a Jewish school now. So, this became a social media sensation. This is the power of social media. I think this case is so interesting given where we are now today, because if you think about if you switched shoes and she said white trash, would she have been fired now? Every day we're getting people now
Counsel,
fired
I think
on the
you're
other
walking,
side.
I think you're walking down the wrong path if you're going to compare which is the worst slur that you could throw at someone.
understand, but-
That doesn't work, does it?
So, counsel, the issue is whether or not it shocks one's sense of fairness, right? Because she was a teacher for 18 years, and so now she was terminated based upon the video. And I think we've all watched the video. And so given what occurred in the video and the tenor of that video, why does that not shock our sense of fairness that based upon what she said and what she did, she should no longer be a teacher in the New York City Public Schools?
Because it's less than 1 minute of a 60.
You can jam a lot of things into 1 minute, and the video shows statements, it shows a gesture, which, according to the school, reverberated in terms of the students as well as the parents and others in the community in terms of what was depicted in the video.
Well, if you look at the analogy to the Rubino case, where she in fact posted something on Facebook and had that kind of notoriety, and this court actually found that she deserved to keep her
Now, I was thinking about that, but in this instance, so this occurred in, what year was this?
2020.
2020. It is now 2025. That video is still up. You can still view that video today, October 21, 2025. It is lasting, right? And so is that something that should be considered? The fact that you can't take it down, it's there.
Well, that's the unfairness, because if you think of Rubino, she posted it, so she had control to take it down. Here,
but it could ultimately be taken down.
she would like to take this down. She didn't even want to be in the video in the first place. Someone else posted this video. She has no control. This is a classic case of being doxxed. I mean, her kids were threatened.
Doxed, counsel, if you have a rally, if you have a demonstration, by definition, any participant will expect to be seen, because that is the purpose of having a demonstration or a rally. And the media comes, people film on their cameras or however it is. So there is an expectation that a public rally will be public. Wouldn't you agree?
But if you go to, unless you went to the three keys.
And you look at the transcripts and you look of what the different students said as to how the video affected them, as to the discomfort that they feel in school, and then you look at the video also with respect to the testimony or the students saying, there were Muslim students who were told to reenact a Muslim washing ceremony, wudu, or risk having their participation score lowered. And then you have the other incident with children who, a student who apparently was told, you don't have to wear a mask, for during COVID because you're what, Chinese, you're Asian. I mean, you just go through those and you say the reverberations of all of this in a school setting is public, and how does that not factor into an assessment as to whether a teacher is appropriately a teacher?
Well, first, with the Muslim, it was dismissed. If you look at the record clearly, that was dismissed. None of these were issues before she went
So
to
we're
that
only
rally.
concerned with the behavior in the video. And as my colleague just stated, it's the total opposite. There's absolutely no expectation of privacy. It is clear that your actions are going to be viewed by the public and maybe online as well.
But she explained that she was in the context of her kids being attacked, and in reaction, you don't see on
I'm
the
sorry,
video,
she was in the context of what?
her kids. She was out there in the rally with her own
Here,
children.
I
they
did
cutting
not
off-
Said the kids were in the car, so I don't
no,
understand
you don't see
that.
the whole video. She was told.
We looked at the whole video, counsel,
No,
please.
But I'm saying what the video was cut off because it was.
But
spliced
that
right into
doesn't,
someone else.
whether or not her children were going to be attacked or were being attacked does not, I don't want to say justify, but that doesn't explain the statement made to the female and her subsequent, making a gesture, I'll say.
But it-
That is not explained by the children being in the car.
Well, what I understood happened, if you read the facts carefully, is she said that someone yelled at her and her kids, "white trash," and in reaction, she said back, "bitch," and so that's
She
what
said
came
more
back.
than that, counsel, didn't she?
Well, there was some times where she said, but even
How
if she
about
said-
Asian
even-
putting in front of it?
even if she said that one time, does that kill someone's
see,
career
but
for the
see-
rest of their career?
Well, here's the thing, counsel. The DOE charged that the conduct was public behavior that created or would foreseeably create a risk of disruption of the school environment and cause DOE to receive widespread negative notoriety after video of the incident was posted on social media. DOE also alleged that the conduct violated the chancellor's regulation in terms of anti-discrimination policy. Now, we're not even going to address the issue that your client stated that she was totally unaware of this DOE anti-discrimination policy. But again, looking at this, did her behavior not create or foreseeably create a risk of disruption of the social environment?
We're not taking the position she's blameless. We're asking to look at the whole picture. And if you look at things like Rubino and you look at Morrow versus Walcott, those were the very factors that the courts that have
Also,
decided.
when you're looking at penalty, when you're considering penalty, isn't it appropriate to consider whether the teacher was remorseful, accepted responsibility, or in any way acknowledged the seriousness or the gravity of what she did?
Well, I think she ultimately did. I think that was sort of misled
Where?
in the record because originally your union will tell you not to say anything, and then she was saying, well, she didn't know not to right away. So when she got to the hearing, I believe she did say that she was apologizing how this got so far.
Did she
There's no
ever
indication that
acknowledge-
this would continue beyond.
Did she
this.
ever acknowledge her exact words? Because she said there was something, she never said that, where the video belies that.
I mean, at the end of the day, she had an Asian teacher came up to testify for her. In the record, if you look at
I don't think that matters if you yell Asian bitch, in the street.
but you have 330. If you look at
So what is it, you're stating that termination is inappropriate, is disproportionate to her conduct. What do you believe that the appropriate conduct would be?
I think time served would be an adequate penalty.
Time
A
served
teacher-
where?
No, I mean, the fact that she's been out of the system for 2 or 3 years gives her the sense that this is a very serious incident, and people deserve second chances.
And do we
I mean,
have
at the
the-
snap of a finger, we're letting people back out of jail.
Do
so-
we, was that put before the ALJ, 1? And 2, do we have the authority to do that?
Absolutely, you did it in Rubino, you did it in, I could. there's
Was that
other-
put
there's an-
before the ALJ? That
The question of the termination was, and he chose the ultimate penalty, it was a just cause standard. He chose to go with the harshest penalty possible, but,
So,
it's a
counsel,
just cause standard.
let's contrast a case that occurred in 2014, okay, where a teacher was caught having sex in a classroom, okay, and the court found that the penalty of termination of employment was shockingly disproportionate to the petitioner's misconduct. Now, that was in a classroom on the 3rd floor while a student function was taking place on the 1st. Isn't this situation presented before us vastly different from that?
Is it worse or different? I guess that's a,
No, no,
that's a
I'm
judgment
not
call.
saying is it worse. I'm saying public, and as far as the repercussions amongst the students themselves.
I believe that that case got notoriety. That was also out there, so that brought similar notoriety. And I think cases like Morrow and Rubino have addressed the notoriety to the system. And it's not so she didn't want to create all this notoriety. It's unfortunate it got this far, but I think there's a point that someone deserves a second chance after a certain amount of time. She's been teaching 3 years at a Jewish school, so if she was so
Didn't one
racist,
of the incidents,
why would
didn't one of the incidents involve a whole issue concerning being Jewish, and you're Jewish, so you should know this?
why would a Jewish school hire her and feel like?
Oh, I can't answer that. You
I
can.
don't, Counsel, that's outside of the record. Thank you.
Okay, thank you.
Good afternoon, Your Honors. May it please the Court. Diana Lawless on behalf of the Department of Education. I think
Counsel, I just want to pick up the thread
Sure.
because the specifications that we're talking about in terms of the Jewish student and in terms of the Muslim student, those were not substantiated by the ALJ. Is that correct?
I think the ALJ's decision is a little difficult to read, but if you follow with me, everything on, that's the second set of charges, specifications 3, 1, 2, and 3, except certain subparts were not sustained, but they were sustained. But I think as part of 4, the ALJ just said that those specific things with respect to the Muslim students and the Jewish students were not specifically discriminatory, but the Asian student comment was. But I think that's just all.
Then that brings me to my second point, because that's one part of it, that they weren't sustained. But then the second part of it, because your adversary seems to argue that because those incidents occurred and were not reported prior to this video that is the source of contention here, should they have been considered at all? Or should it be the basis for shocking the conscience?
Well, I think I'll start again with saying he wasn't in this appeal. He's challenging the penalty, not the finding by the ALJ. But I think it's a whole thing that Your Honors can see. These were middle schoolers. These were 6th and 7th grade students. What happened here, as Your Honors talked about, this video went viral. All the kids were talking about it. Everybody was emailing the school on social media with the school as an uproar for the school. And I know my adversary said, oh, they started investigating the kids. They got complaints. The OEO of the Department of Education has to investigate complaints of discrimination, harassment, and they did and undertook a thorough investigation and found out that many things had happened in the classroom. And
Counsel, why isn't this a momentary lapse of judgment where the penalty of termination shocks the conscience?
well, I think that this is. I think what my adversary is talking about is a lot about, like, oh, I disagree. That's not the standard. It's whether it's so disproportionate to the offense. I think we start that there's no dispute that even the video event by itself was a violation of A830, which is the
I'm sorry.
A830.
No, repeat that.
To start, this was, even the conduct on the video was a violation of the
But
non-discrimination.
she didn't take the video. Someone else took the video.
No, her conduct was a violation.
Okay,
Right.
thank
Her conduct, as captured in the video, is a violation of A830, and that she knew or should have known. In fact, the petitioner testified that she knew cameras were in her face. She knew or should have known, based on her trainings, that you have to behave professionally and in a non-discriminatory way, even outside of the classroom.
But again, we have 18 years of unblemished service in the Department of Education.
Well, I don't know we can call it, I know everybody always says unblemished. Unblemished means there just hasn't been a record, right? First thing we know is.
Well, I mean,
we're looking
unblemished-
at.
I
and what's
understand,
part of the record.
But we do
right?
know, though, here that once this happened, there were many complaints from
But during
students
the 18 years, there were no complaints.
that got this, right? There were no complaints that got this far during the 18 years, but I think that the case law is clear that this specific policy is a very important one for DOE. It's important for this school. This is one of the most diverse schools and one of the most diverse, probably the most diverse borough county in the world. There were students from all sorts of backgrounds.
Is that the same policy that was applied in Morrow versus Wolcott and in the other cases that we've discussed, where the penalty of termination was overturned and the matter was remanded for a lesser penalty?
So I have two answers. One is I don't know that any of those cases implicated the specific non-discrimination policy, which does notice the teachers that that termination is a
I
possibility.
don't think Morrow did. Morrow had nothing to do with discrimination.
But the next thing that I'll say is, as your honors know, those cases predated the Court of Appeals decision in Bolt, where the Court of Appeals made clear in 2018 that just disagreeing with the penalty is not enough, and it has to be something that truly, truly shocks the conscience.
Is there anything to the fact that she's indicated she wasn't aware of the policy, the non-discriminatory policy?
I mean, it can't be true based on the testimony of the principal, the document that she had training. There's a sign-in sheet from a training she had attended specifically on this, a half-day training for DOE teachers in Queens on this policy. There also was that before the first day of school, they had specific trainings on this. She signed a piece of paper that's in the record saying that she read and understood the policy.
Ignorance is not a defense in this case.
It's not knowledge. The lack of knowledge is not a defense. It wouldn't. It's
Okay.
all the employees are
So
charged.
now, if the specifications regarding the students were not sustained, then we're only dealing with the video. And you're saying that just based on the video alone, we should uphold the penalty of termination.
I think in terms of if you're reviewing what the arbitrator said and the arbitrator's decision, which is well-reasoned, I think still took into account the other things, yes, because this was serious misconduct in the context of the school, in the context.
Should we take into consideration the fact that, as she stated it at the hearing, she went into mama bear mode and was protecting her kids? Because I did see in the video, I did see two children running across the street towards a van, and they did enter the van, and they did lock the door, but she was still outside. But her children were there, weren't they?
I think there's evidence in the record that the children were there. I think, again, that there's no...
So should we consider all of those circumstances in judging her behavior at that moment?
Well, I think it's reviewing whether the arbitrator did... you can't just reconsider the facts de novo, I believe. I think you have to take into account whether the arbitrator's decision on the facts are supported or not. And there's no basis to find what the arbitrator said, that the statement was, she made this statement. Yeah.
Termination is one extreme, and then you have other penalties that the arbitrator could have imposed.
Yes.
Correct?
Right.
So, given the fact that we were only dealing with the video, and that certain things happened there that the arbitrator acknowledges, and obviously disregards because he imposes the ultimate penalty, are we not entitled to review the record and to say, just based on the video, and given the circumstances, the other circumstances present, terminating her 18 years, 20 years on the job with an unblemished record shocks the conscience?
Only if you find that the arbitrator's reasoning made this so disproportionate to the offense that it's...
But I think that's the question.
Right. I mean, I think it's not, and I think it's, we laid it out.
Because it's, if we just look at it in the context of the video incident compared to the 18 years of service, why is that not disproportionate?
Right, I think there's several things, and I think it's that, as your honors discussed before, this was something that really, really rocked the school. This is a teacher teaching middle school students who all of a sudden everybody was coming to the school and saying, this teacher is racist, the school is racist. Several students testified about how uncomfortable.
Does she need to go back to the same school?
Well, I don't know that she would need to go back to the same school, but I mean, I also don't recall how much of this all was discussed, but in the hearing in itself. But I think it's also important that it's not just this specific school, it's that it's affected the ability to perform in the classroom.
That teacher in Morrow, did her ability to perform in the classroom, was that also impaired based on the fact that she was basically found engaging in a sexual activity inside the school, in a classroom in the school, although school was not in session, but she was there, and there were children, there was a concert taking place in the school when she engaged in this behavior. Do you think that teacher's ability to perform in a classroom was impaired?
I mean, all I know is the DOE in that case argued that termination was the appropriate penalty and got
And
reversed.
in Morrow, we found that it was a single lapse of judgment, and we stated that that act did not harm the students, nor did it affect the teacher's ability to teach.
Yes. And I think
And so in this case, you are stating that her actions in the video harmed the student and also affected her ability to teach.
Yes, because we have evidence. This isn't just gossip in the school. This is students who came and testified before the hearing officer that they would not feel comfortable having this teacher in the future. Parents who wanted their students removed from the school, people who were worried about the learning environment. And also, I think that the lack of remorse is...
There was testimony by one of the students about one student who was singled out, who used to be happy and tell jokes and now stopped doing that and only looked down at his desk.
There was testimony, and there were also many emails from students who were saying things about how they would feel, stressed to be in this situation moving forward. And I think that in terms of why is there not remediation, the remediation is not a prerequisite. The statute says you may consider it not must. And then what would the remediation be? Trainings. What do we know? This person had trainings. So DOE is left with not knowing what to do with this teacher who has been instructed many times, this is DOE's policy, this is how we treat people with respect in the classroom and outside the classroom. And that that's not what happened here. And I think also the reaction, lack of remorse, do support the penalty. I have a whole bunch of cases. Lack of remorse can be considered. I have a different read, understandably, from my adversary that this teacher kept telling. I understand it wasn't that she wasn't just told not to talk by her union. She just kept saying, oh, this had nothing to do with the DOE. This was outside of school. This had nothing to do with the DOE.
She said it wasn't, am I correct? She said she didn't say Asian, she said Caucasian.
Right, and that came, again, I think we're not challenging the factual findings, we're challenging the penalty, but her testimony, which didn't come up, as the hearing officer said, not, the arbitrator said, it wasn't, this theory developed only when she took the stand, not in the opening statement of counsel. All of a sudden, that was what she did, and she was trying to minimize the conduct.
Thank you.
Okay, thank you, Your Honors. We ask that you affirm.
I'll just be very brief. I think I appreciate the court, grappling with the penalty phase of this, and it's pretty clear from this record that had not this been, someone posted this for 58 seconds, none of these previous complaints would have come out. It went viral as soon as it was posted, and all these people sort of piled on. And you'll see in the record for and against her, and they believe she went too far, but that's the country we're living in right now. So I think you need to understand, for one lapse of judgment, this was it. Everything else emanated from that. Everything was bootstrapped to that. And so that's what we have here. And as far as the policies, come on, and sleeping with another teacher in a classroom is not a violation of the board policy. These policies are written.
Again, Morrow talked about, yes, it was a lapse of judgment, but Morrow also talked about the fact that it did not harm any students or affect the teacher's ability to teach. In this instance, the contention is by DOE that her actions did in fact affect the school, did in fact harm students, and affected her ability to teach.
And the aftermath of that, I agree that probably it did have some impact at that point. Is that going to continue today, 3 years later, when someone is,
the video is still there. She comes into the classroom, first day of school, whatever, folks may go online and they will be able to view the video. And by the way, in Rubino, she took that down. She took it down after 3 days off her Facebook.
And I'm sure Ms. Garani would love to take that down too, but
I know, but I'm just saying that in Rubino, my point previously was that this has lasted 5 years. In Rubino, she posted the video on Facebook, but then she took it down after 3 days. So it no longer can be accessed. This can still be accessed.
It also went viral, and then she was on TV. It was all over the place. It has not really gone away. You can Google her name. It's never really gone away, and she's still in the system. So people can recover from these things. It was a lapse of judgment. It's unfortunate. I would ask you to just give her a second chance to continue an excellent teaching career other than this one blemish.
Thank you. Thank you both. Certain underwriters at Lloyd's, BSF Corporation.
May it please the court, Linda Bennett on behalf of the appellant defendant, BASF Corporation. BASF is the insured and true plaintiff in this action, and the trial court erred in two material ways by failing to consider judicial estoppel and making place of contracting a super factor in the comedy forum analysis, while New Jersey is the nerve center of.
First in time, where was it filed first?
The first filed action was BASF's action in South Carolina.
Plaintiff underwriters was not part of that action, or were they?
Plaintiff's underwriter was one of the London companies were part of that South Carolina action, and they certainly could have done a third-party action to bring in the other carriers that they brought into this case, Your Honor.
But they did not. So
They did not.
the first action between New York and New Jersey was filed in New York, was it not?
That's correct, but it was only a matter of days before BASF filed the...
Does it matter?
It
Is
does matter.
It does?
It does matter.
In terms of our case law, it states that it matters in terms of when that first action was filed?
It matters when the second action is filed in temporarily close time period, and because BASF is the true plaintiff in this action. They are, the insurer is the true plaintiff in a coverage litigation. But on top of that, and what's really at the core of this appeal, Your Honors, is the judicial estoppel point. These carriers told two separate courts that New Jersey was the place that this coverage action should proceed, and based on those representations, they got results. They got the South Carolina, the first BASF's first.
Was it that they said that New Jersey was the more appropriate than South Carolina, but did they really consider the difference between New Jersey and New York when they made those representations?
They did. And I'll use their words. They say it best. What they told the judge in New Jersey is that it's inescapable for BASF is the fact that the New Jersey action is more comprehensive than the London action, meaning this New York action, or the action that BASF initiated in South Carolina. That record site is R1156. They also said that, and this is a really important representation they made to the New Jersey judge, resolution of the London action, this New York action, will not end this litigation. Thus, if any case should move forward, it is this one that is the most comprehensive coverage litigation filed in the state where BASF is headquartered. That's what they're telling the New Jersey judge when they don't want our first filed action in South Carolina to move forward. They're saying the New Jersey court should not stay the New Jersey action in favor of the, quote, less complete New York action where 7 parties.
Do a lot of these cases involve New York policies?
So these policies were issued to an insured in New York 50 years ago. There is no, but for purposes of this dispute, New York has the most remote connection out of any of the 3 jurisdictions. And these exact policies with these exact insurers have twice before been litigated in New Jersey. The insurers did not move to dismiss those cases in New Jersey. It didn't raise the fact that the policies were issued to a New York insured in New York.
New York insurance law control?
I'm sorry?
Would New York insurance law control?
That will depend on the jurisdiction in which choice of law is considered. That wasn't what was in front of the trial court on this motion. What we're talking about right now is comedy, which jurisdiction should have the case to hear.
Was there ever a statement that New York would be somehow inferior to New Jersey?
The insurers themselves said that. Those are representations that they made both in New Jersey and in South Carolina to Judge Gergel, saying that New Jersey had the most comprehensive at the time. And in fact, even at the time we filed our motion to dismiss in this case, the New Jersey action was more comprehensive because it had more defendants.
Was that a representation by the AIG and insurers and the Allstate insurers, or the certain underwriters?
The insurers.
Are you lumping them all together?
So AIG, I've got a representation that AIG made to Judge Gergel. That litigation in New Jersey should proceed because if BASF didn't want to litigate in this action, they shouldn't have commenced it here. So they were telling Judge Wolonitz in New Jersey that the case should go forward when everything was centralized in South Carolina.
But is that necessarily a statement that that an action in New York would be improper?
Yes, the statements that they made, and I can keep going. I've got a whole list of them where each time in New Jersey and South Carolina, they're telling the judges New Jersey is the place to be. By the way, when we filed in March of 2024, none of these carriers moved to dismiss. They answered the complaint. They served discovery in New Jersey. It was only after the South Carolina action and was abstained in favor of the New Jersey action based on the representations that the insurers made.
Wasn't it that action in South Carolina, wasn't it basically dismissed for lack of subject matter jurisdiction because there was no diversity of citizenship?
No, Your Honor. The first filed South Carolina action that BASF filed, Judge Gergel abstained in favor of the New Jersey action based on representations that the insurers made. The action that you're referring to is the New York action. We had removed it up to federal court. The JPML sent that action to South Carolina. The insurers then, again, making another representation, realigning themselves to destroy diversity to send it back. But that doesn't change the representations, and the reason that Judge Gergel sent this case, abstained from taking the case, was to send it back to New Jersey, not to this court, based on the representations. Thank you, Your Honor.
May it please the court, good afternoon, Your Honor. Matt Anderson for the respondents, the London Market Insurers.
So could you address the estoppel issue?
Absolutely. BASF has identified no statement of the London Market Insurers that somehow the New Jersey action should go forward over the New York
Said that
action.
I believe your friend stated that the statement was made that the New Jersey action was more comprehensive, I think she said.
So just backing up a step, when BASF took a tactical decision to file first in South Carolina and didn't name the London Market Insurers because it would defeat subject matter jurisdiction in federal court. So the London Market Insurers filed in New York to seek assistance of the court to issue a declaratory judgment over this coverage dispute. And what the London Insurers did was name all of the insurers in South Carolina, as well as 7 insurers that weren't named in South Carolina because they would defeat subject matter jurisdiction. And London also named John Doe insurance companies with the intent of capturing all the insurance companies that were known at that point in time. And so as this court said in the Sencora case in 2013, it's substantial identity of parties is enough to suffice on the test. And so there is a dispute about, does New Jersey have more insurers or does New York? I believe with AIG's third-party complaint, there are more insurers in the New York action, but it's not a counting exercise. And the point here is the trial court acted within its broad discretion to determine that, in fact, there was a substantial identity of policy
So was there any clear-cut statement by any of the insurers that New Jersey was the proper forum and New York was not the proper forum?
I can speak for my clients, the London Market Insurers, the plaintiffs. From day one on March 4th, 2024, when they filed this action in New York, they have been steadfast and consistent that this New York action is the action that can proceed. You do not hear from BASF any statement that the London Market Insurers made because there are none.
So when BASF is making representations about parties making statements against their interest on this particular position, it's not the London insurers.
It absolutely is not.
And the London insurers, again, are the plaintiffs in the New York action.
That's absolutely correct. And I think BASF also overstates what the insurers said, the other insurers. When the case was, London was not in the South Carolina case, but when the insurers in that case filed a motion to have, abstention, right? An insurance coverage case should be in front of state court, not federal court. That was the gravamon of that motion. The insurers were very clear to the court in South Carolina and said there's 2 state court actions. There's New York and there's New Jersey. And it'll be up to the state courts to determine which action goes forward. And that's exactly what happened here. Within 6 days of the stay being lifted in New Jersey, London filed a motion to dismiss, and the court in New Jersey, in the principles of comity, deferred and let this action and this issue about which action should proceed be decided in the New York state court system.
Counsel, where were the bulk of the policies issued?
Right. So the gravamon of this case is New York. Absolutely. The policies were delivered through a New York broker to a New York insured, and the policies are grounded in New York. The trial court will need to apply and analyze these New York policies, and the parties, New York law, as the trial court found, will most likely apply to these policies. And even BASF themselves have taken the position that New York law applies to these policies, and it's at transcript page 753. And in that is their brief when this case was in the federal court. They filed a brief, and they said, we cite the Olin case, which cites the Court of Appeals in Viking Pump, which is all sums allocation spiking, which is New York law, which is completely different.
So let me ask you a different question. These policies were issued to CIGA, C-I-G-A?
Yeah, it's CIBA Geigy, yes.
CIBA, thank you. Your colleague says that, or your adversary says that that was a long, long time ago, so that doesn't really count.
Right. So the trial court evaluated all the Pavlovi forum non-convenes factors and found that, the policies were delivered here, but also in addition to that, while there's nationwide risks with these claims, over 300 New York plaintiffs in the underlying cases have brought cases against BASF, including the town of Islip and the Port Authority. And that's more than is taking place in New Jersey. In addition, BASF has active operations in New York, and in fact, they have an operation in Tarrytown where that still to this day where the 2008 insurance policies were delivered. And so the trial court evaluated all of this and found that the Pavlovi factors dictate that this case move forward, and BASF has not identified any error of law, and the court's decision should be granted. Thank you, Your Honor.
Good afternoon, Your Honors. Alex Lorenzo, counsel for respondent defendants and third-party plaintiffs, the AIG insurers. I just want to add a few points to the points raised my co-defendant's counsel. There's been a lot of focus on the statements that the AIG insurers made. What is clear is throughout this litigation, the AIG insurers' preference was to be in state court rather than federal court. When you look at, there have been statements about what was said, but when you look at the actual record, and I think we highlighted this in the brief quite well, I'm looking on record page 777, which is our brief to the South Carolina judge, and there's a footnote that I'll just read. Moreover, the New York action, this action, is currently pending in federal court upon BASF's removal. Accordingly, there is only one overlapping state court action, the New Jersey action, close paren. Should the New York action be remanded to state court, and there are two pending state court actions, those state courts' procedural rules will govern which court should abstain. New York may be the more appropriate forum. Many of the policies were delivered to BASF's predecessor in New York, and the New York action was filed before the New Jersey action. So we've been clear throughout. There's also a little bit of sort of upside downness in the record, because if you look at BASF's brief to the New Jersey court, and this is 778 in the record, their position is that, in fact, the New Jersey action should be stayed in favor of the New York action. Now, at the time, the New York action was before Judge Gergel in federal court, but the relief requested, I'm looking at the conclusion on 792 of the record, for the foregoing reasons, BASF respectfully requests the court stay this action, again, the New Jersey action, until 30 days after Judge Gergel adjudicates the New York action. All that has changed is Judge Gergel has remanded the New York action to New York State Court, but there's no reason why the New York action cannot proceed, and there's nothing in the record indicating that the trial court abused his discretion. The last point that I will mention, there's a mention in BASF's brief that perhaps the personal preference of the trial court is somehow clouding the trial court's judgment on these issues. But if you look to our brief, page 49, we cite to the Clariant case, a case that I was involved in, a similar PFAS coverage dispute, and there the court granted Clariant's motion to dismiss on forum non-grounds. Again, we opposed, I'm not saying that I agree with the outcome, but it shows that the court is consistently applying the principles that this court has set out. I think the Valet decision from 2023 is quite clear on those factors.
Thank you.
Thank you.
Your Honors, just very briefly, I think it's very important for Your Honors to recognize that London did not move to dismiss the New Jersey action immediately. In fact, in August, very shortly after the JPML sent this action to South Carolina, London answered the complaint in New Jersey, served discovery in New Jersey. So if their position was that their first filed action should go, one might wonder why they didn't file a motion to dismiss right then and there. Instead, they lined up right behind all of the other carriers saying New Jersey's the place to be, we got to get going in New Jersey, while BASF has remained consistent in its position throughout that we followed what Judge Gergel directed in another case to file in South Carolina, and we kept telling the New Jersey judge, let's wait and see what Judge Gergel does with all of these different competing actions. So we've remained consistent. The carriers have gotten results based on representations that New Jersey should go first, and judicial estoppel, respectfully, if it means anything, it has to mean something in this case. This case should be dismissed. Thank you.
People v. Anthony Gonzalez.
Delorne Namoran, Legal Aid Society, on behalf of Mr. Gonzalez. The legal error before this court is that the judge below did not know that bail in the second degree could run concurrent to the remaining charges. The statute at question is
Bail jumping.
Yeah, bail jumping. The statute at question is Penal Law 70.25-2-C. The sentencing for second-degree bail jumping is presumed to run consecutively with the underlying case. However, the statute also permits, in the interest of justice, to order the sentence to run concurrent if it finds mitigating circumstances that bear directly upon the manner in which the crime was committed.
What were the mitigating circumstances that were placed on the record at the time?
So, Your Honor, there were no mitigating circumstance placed on the record at the time because prosecution and defense are all discussing with the judge, can bail jumping be run concurrently? Can bail jumping be run concurrently? The judge admits at one point, this is the transcript, the plea transcripts, the minimum you can do here, as I understand it, I could be wrong, it is late, I'm tired, is 2 to 4 on each count on the 2022. They run consecutively for a total of 4 to 8.
So this is the time of the plea, is that correct?
Your Honor?
This was at the time of the plea?
Yes, right before Mr. Gonzalez is allocuted.
Okay, so there's an allocution, and he enters the plea with the understanding that it's going to be consecutive. Is that correct?
Yes.
So now he comes back. Does he come back for sentencing?
He does not come.
Why is that?
Your Honor, that is because there's a mutual misunderstanding of law.
He doesn't come back, so there's a bail jump, right? Does he come back for sentencing?
Yeah, he does come back.
Okay, that was my question. So
Okay.
he comes back for sentencing.
Yes.
So when he comes back for sentencing, does he say, oh, wait a minute, it can run concurrently? Does he move to withdraw his plea at that time because it's going to run consecutively and not concurrently?
No, Your Honor, he does not.
So there's no motion to withdraw the plea?
No, Your Honor. Just like in People v. Joseph, which is a case from this court in 2018, where you cite the Court of Appeals, People v. Lorre. A defendant cannot be expected to move for a plea withdrawal on grounds in which he has no knowledge. The court, the prosecution, and the defense counsel, everyone is getting clarity, and the judge at the plea hearing repeatedly says, by law, this must run consecutively. By law, this must run consecutively. By law, this must run consecutively.
So what did we say in People v. Concepcion? In People v. Concepcion, did we talk about preservation? Did we talk about the fact that there was no motion to withdraw the plea?
Yes, Your Honor, but this falls under another narrow exception, Your Honor, where all parties, prosecution, court, and defense counsel are under the belief, as the court states, that by law, this must...
the defense counsel has its own duty to his client, right? To know the law?
Yes, Your Honor, it does, but when the...
And so if there's, like my colleague pointed out, even if not at that moment, when the person came back for sentencing, the issue could have been raised, there could have been a motion to withdraw, there could have been clarification sought on the record.
Your Honor, I agree with you, but when the defense counsel asks the judge does have an obligation to state the law accurately in its entirety. I understand in this case there was a discussion and question about the consecutive sentences. The judge told Mr. Gonzalez during the plea allocation that the bail jumping must run consecutively. There also, I understand the obligation on defense counsel, but there is also that the court cannot just misstate the maximum, the sentence.
So judges
when
make
required.
judges make mistakes too,
Of course, and
okay?
everybody makes
Well, I
mistakes.
don't know if you say of course, but judges do make mistakes. So I think what my colleague was getting at is the fact that he was represented by counsel. And again, it is incumbent upon counsel at that point in time to point out that it doesn't have to run consecutively if in fact there are mitigating circumstances.
Yes, Your Honor. In People v. Joseph, People v. Johnson, both First Department cases, there was a mistake of fact stated by the judge in regards to sentencing exposure with no plea withdrawal, and this court still addressed the issue.
And in People v. Conceicio, CONCEICAO, as well as Lori, in both of those cases, we stated that where the defendant had a practical ability to seek relief from the sentencing court, he should have done so. Failure to do so does not render the plea invalid.
Yes, Your Honor, but in this case, the mistake of fact is on the record.
Counsel, so there was a mistake of fact, right? So the judge thought that it had to run consecutive. Did that inform or did that influence the defendant's decision to plead guilty? Isn't it true that the defendant here was a discretionary persistent felon?
Yes, Your Honor. When we think about the voluntariness of the plea, we address the totality of the circumstance.
Correct.
And it is not reduced to just how a respondent says, well, it was a good offer. In People v. Joseph, there was a YO, and the defendant at that case was exempt from any incarceration time. And the court held that the misstatement in regards to the sentence still held the plea to be involuntary.
Was this plea and sentence in line with the people's offer?
Well, the people also is trying to inquire on whether the sentence can be consecutive, ran concurrently. The grand
Was
larceny.
there an alternate offer being considered that the sentence didn't have to run consecutive?
Your Honor, repeat your question, I'm sorry.
Was there an alternate sentence being considered, an alternate plea, had the answer been that it did not have to run consecutive?
Your Honor, I'm not clear, but I know the prosecution as well is inquiring about the concurrency of the bail jumping in the second degree. Grand larceny in the third and the fourth both run concurrent, and the prosecution is also engaged in this conversation as to the concurrency of the bail jumping in the second degree. So it's a group discussion, Your Honor, so therefore I cannot state that it is only defense who is seeking that the bail jumping be run concurrent. Everyone is having that discussion on the record, seeing my time.
Yes, you have time on rebuttal, it's okay.
Good afternoon, Your Honors. Jamie Masson for the People. If I just may address and start with the confusion that appears on the record. We understand there is confusion at the start of this plea proceeding, but the idea that the parties are hopelessly confused about how the concurrent terms and consecutive terms are supposed to run is not borne by the record. The misstatement actually started with the people. When the people put on their record the recommendation, they attached a wrong term sentence to the charge. They said that our recommendation is 1 to 2. That's actually not a legal sentence.
That was an unlawful
And so,
sentence.
Oh, I'm sorry?
That would have been an unlawful sentence under the circumstances.
Exactly. And immediately the court catches it and says, wait, I'm confused. What are you talking about? And the rest of that discussion is a conversation between the court and the people in trying to nail down and pin down exactly what the people's recommendation is. And that's why when the court is repeating over and over, you can't do 1 to 2, you can't do 1 to 3. I don't know how you're getting 1 to 2 here.
That's what I was alluding to before, that the fact that this error was made, did that in any way affect the defendant's decision to plead guilty?
Not at all, and I think the other part of your question hinted at why it didn't affect his decision to plead is because he was facing such a long sentence if he didn't take the basically very lenient terms of this plea agreement. And even if this was in any way a sentencing misapprehension by the court, which we are going to dig in and say there absolutely was no error here, the error would have affected only the minimum, what the minimum terms were. And in every case in which the court made some sort of sentencing misapprehension, it always had to do with the maximum. And that makes sense because A defendant is not going to be
Well,
compelled.
it's different to think that you're going to get your exposure is 45 years when it's really 20.
That's exactly right, yes. And to answer Justice Pitt-Burke's question, there were 0 mitigating circumstances placed on this record. At no point did they make a mitigating circumstances claim or argument or put them on the record. On page 4 of the sentencing transcript, counsel references the pro se letter that the defendant sent to the trial court, as well as another letter that he sent to the Bronx. And counsel did not adopt that letter or the motions or any arguments therein. Instead, she did the opposite. She said, these types of ex parte letters are not going to be answered by the court. So she waives any claim of mitigating circumstances. And I want to go back to this idea of, aside from preservation, aside from the fact that there was no 440 litigation, which means that the ineffectiveness claim is not properly before this court, aside from those procedure hurdles, there is no error here. The court did exactly what 70.252-C says, and her understanding and application of that statute was entirely correct. There's nothing erroneous about saying that the bail jumping sentence by law must run consecutively. That is the plain language of the statute. And there's no obligation of the court to recite the remaining discretionary portions of that statute, which are basically hypotheticals upon hypotheticals. That may have only added additional confusion. What is clear is that once the court dispelled the confusion over the people's recommendation, the defendant assured the court that he understood every aspect of the plea, the terms of the plea, the sentence, and that it was exactly what he wanted to do. Basically, this court, the defendant here is asking this court to infer the trial court's ignorance based on her not doing something sua sponte that she was not obligated to do. And we know that the trial court was not obligated to mention the discretionary portions of 70.252-C because this court has made that exact same decision in the context of the parallel provision of 2-B, which has the identical language and has listened to the exact same claims. And this court has rejected them and said that there is no independent obligation to make findings of mitigating circumstances. If there is no mitigating circumstances application, let alone a finding, which there was none here, the sentences must be consecutive. Absent mitigating circumstances, a sentencing court, quote, has no basis to order concurrent sentences in the interest of justice. There is no error here. And this court's holdings is actually supported by the Fourth Department's holding in People v. Dunbar, which specifically cited this court's decisions in both Dialby and Hamlet. So following all of this precedent, the judge said and did exactly what she was supposed to do. If your honors have any questions about the excessive sentence claim, I'm happy to answer them.
No, thank you.
If not, we rest on our brief. Thank you.
Your Honor, as respondent clearly states, the plea hearing starts with confusion. Starts with confusion from the prosecution, and then the court's trying to clarify that confusion. Your Honor, I want to be very, very clear also that this court in People v. Branham, First Department 2009, also modifies the sentence of second-degree bail jumping and third-degree criminal possession of a controlled substance after finding mitigating circumstances.
So in terms of mitigating circumstances, something that your friend reminded me that I saw on the record was that your client did in fact write a letter to the court. And while his attorney did not adopt it, it was entitled something like mitigating circumstances, which seems to suggest that he was not confused and that he was in fact aware of the fact that a concurrent term of incarceration was a possibility upon the establishment of mitigating circumstances.
Your Honor, I cannot, the record's not clear as to why he did that and what his understanding of the law was. But I completely agree with you that there was a pro se motion and it was entitled mitigating circumstances, and that was put into the record even though defense counsel did not adopt that motion.
Right, but it was mitigating circumstances for concurrent sentence, I thought. I thought that's what the letter said.
It was titled Mitigating Circumstances and Program with a Concurrent Sentence.
And program with, right, exactly. So again, that I thought that it suggested to me that he was aware of the fact that if you could establish mitigating circumstances, he would be entitled to concurrent time.
Well, Your Honor, the defense counsel believed that he was not allowed to do so by law, and I think there was some attempt to get clarification about that. And when the court denied, state that could not be possible, perhaps that's the reason why the defense counsel did not adopt the motion.
Well, we don't know because we're kind of in the dark. One, because he never moved to vacate his plea, and two, because there wasn't a 440, right?
Well, we're also in the dark, Your Honor, because the defense counsel agreed with the court. That's also a discussion was happening in the court, and the court was confused as to the plea. And not only the court, prosecution as well, as respondent makes clarify, the hearing starts with confusion from the prosecution. As your colleagues wondered, would the sentence have changed if we knew concurrent sentence were feasible? And we don't know, Your Honor, but we do know that this offer was not clear at the start of that plea hearing. There was clear discussion as to the offer while we were at plea. And once we decide that by law they must run consecutively, that is only at that time does Mr. Gonzalez plead guilty based on that colloquy. And for those reasons.
Thank you both. Law Offices of Cyrus Jobin v. the Manhattan District Attorney's Office. Yes, please.
May it please the court. Good afternoon, Your Honors. Christian Rose from the Manhattan District Attorney's Office. This court should reverse Supreme Court and find, in accordance with an unbroken line of cases, that the data sheet here contained attorney work products, and in any event, reverse Supreme Court's award of attorney fees because the office had at minimum.
There's a prior case, actually. Ooh, it has the same name. Matter of Law Offices of Cyrus Jobin, Esquire v. Manhattan District Attorney's Office. Same name.
That's correct.
Same case. First Department, that's us, 2025, where we specifically stated that the DA worksheet, DA data sheet constitutes work product, and therefore it is not subject to disclosure under FOIL, and it's not subject to disclosure even with redactions.
That's right, and I believe Justice Pitbrook was also on that panel as well, so even more similar.
There you go. Thank you so much. Yes.
May it please the court, Cyrus Jubin for Law Offices.
How is this case different from the one that we heard where the order was issued in January?
Because it was a different data sheet with a different judge who looked at the specific data sheet to see if there was attorney work product. Justice Moyne found that there was attorney work product in that data sheet. Here,
The DA data sheet is a DA data sheet. Each case generated in the district attorney's office will have a DA data sheet. It is the same thing. It contains work product, regardless of what case it is attached to.
well, if Your Honor is stating that the DA data sheet is a per se categorically exempt document, that runs afoul of the Court of Appeals.
I think in our prior decision, we indicated that the court properly concluded after an in-camera inspection that the subject data sheet constituted attorney work product protected from disclosure pursuant to CPLR 3101C, and that it need not be disclosed subject to redactions. How is that different than what needs to be applied here?
I would say the court should render precisely the same decision with the opposite. In other words, defer to the judgment of the Supreme Court. The justice in that case, Justice Moyne, looked at the data sheet in issue and specifically said, I find attorney work product. By the DA's own admission, not every data sheet is attorney work product. They concede that.
I'm sorry, what case are you referring to where this was stated? You said the Supreme Court?
Excuse me, in terms of the...
Oh, you're talking about Judge Kelly?
Yes, in this case, Your Honor, this is a different judge entirely, a different data sheet entirely. And Justice Kelly looked at the data sheet here in camera, reviewed it. In fact, before doing so, in his decision asking the people, the DA, to give him the data sheet, he stated, not
he ordered redactions, right? And some of those redactions were of work product.
No, there's no redactions issue. The redactions Justice Kelly ordered were for personal identifying information or sensitive information, such as the phone number of the police officers, dates of birth.
And doesn't it include to be redacted to eliminate non-factual materials such as opinions and recommendations?
Justice Kelly did not Justice Kelly did not issue that order. In fact, attorney work product cannot under FOIL be redacted. Personal identifying information or intra-agency communications can be redacted, but not attorney work product. So
if a document contains attorney work product, then it doesn't have to be turned over, correct?
If, just to make sure I understand, Your Honor, if the document contains attorney work product, that's correct. It does not have to be turned over.
It's not a situation where that work product could be redacted and you turn over the rest.
That's precisely correct, yes. And so,
Are you trying to do an end run around the prior decision?
no, the two cases were filed, no. The cases were both pending at the trial level this concurrently, so I wasn't.
The orders on appeal here, were they issued before our January decision or after?
Justice Kelly issued his decision, I believe, prior to this court's decision.
About a year prior,
Yes.
right?
Yes.
But the fact remains that in those cases, in the prior case as well as the additional cases that we have decided, we've talked about the DA data sheet generically, that there's one DA data sheet, as I stated, in each case, and they're not subject to disclosure under FOIL with redactions or without redactions.
Well, that is true, Your Honor. There have been numerous cases that have found that the DA data sheet contains attorney work product, but that is a case-by-case assessment. Here, Justice Kelly, who in other cases has found attorney work product in data sheets, looked at this in camera and said there is no attorney work product.
I don't think we've ever stated that it could be decided or should be decided on a case-by-case basis. I think we've always stated, just as bottom line, that they're not subject to disclosure under FOIL.
Respectfully, Your Honor, I believe that the appellate courts have always looked at the specific data sheet at issue and have never, there has been no case that has ever found that data sheets are categorically exempt. That would run afoul of Gould, which prohibits categorical exemptions of wholesale exemptions of documents as attorney work product. These need to be assessed on a case-by-case basis. And I think Justice Kelly's decision when he orders the DA's office to turn over the data sheet states some data sheets contain attorney work product, others simply contain factual information. And Justice Kelly looked at the data sheet at issue here.
Counsel, if the data sheet here contained the recommendation as to bail conditions, would that be work product?
No, for two reasons. First of all, a bail decision is stated on the record, and that is stated on the record.
That's not the question. The question is that the recommendation from the intake ADA to the ADA that's on the stand and departed arraignment. If there's a recommendation from the intake ADA in that data sheet as to what should be done with bail, that's not work product?
No, I don't believe it is. I believe the analysis, the legal analysis that goes into that decision, if that were articulated, that would be attorney work product.
What about a possible disposition of the matter? If that were to be included in the data sheet, would that be considered attorney work product?
If there was a proposed disposition, that is also, the analysis that goes into that disposition would certainly be protected.
So what if it just says A in a year? What if it just says A in a year?
That's not work product. That's
not work product.
That's the conclusion. I mean, that's the DA's position, which they express on the record. That's not the analysis. That's not what's protected. And I think
Offer A in a year.
that's not work product.
Thank you. Thank you both. Elementary duplication services.
May it please the court. Good afternoon, Your Honors. Stephen Rickershauser on behalf of respondents, Duplication Services, and Pelco Prints. I will be brief. The motion court correctly denied plaintiff's motion for summary judgment because genuine issues of material fact exist regarding, one, whether there was ratification by the parties of the 1996 Pelco agreement following changes in ownership and corporate structure of plaintiff's employer, and two, even if so, whether or not there was an oral modification of plaintiff's compensation terms thereafter. Plaintiff has failed to present any viable basis to revisit the lower court's decision on these issues. As the Court of Appeals has made clear, movement bears the heavy burden of establishing a prima facie showing of entitlement to summary judgment, and he has failed to do so.
I'm sorry, who do you represent?
Respondents, Duplication Services, and Pelco Prince.
But you're the respondent. Who's the appellant?
Correct. The appellant is not here, Your Honor.
Okay. I'm sorry, go ahead.
Sure. Plaintiff's failure to meet their prima facie burden here warrants affirming the lower court's decision, regardless of the sufficiency of defendant's opposition papers. Plaintiff asks this court to overlook irrefutable evidence that these parties, particularly Duplication Services and the successor DMS, were not parties to this 1996 contract. Nevertheless, the evidence submitted by
So
defendant.
is there anything in the record which states the relationship between Pelco Prince and Duplication Services and how they are connected?
At this
connected?
time, there's nothing in the record beyond the affidavits of the parties, which I would argue is insufficient to establish.
There's nothing to show the connection between the two in the record?
No, Your Honor.
Thank you.
Is there anything in the record to show the compensation package, the employment agreement with the appellant?
So through discovery,
'Cause I'm looking at Record 178, which is the original agreement with Pelco Prince, and then I'm looking at Record 572, and that is also with Pelco Prince, and it's all laid out. But was there any modification or written agreement or anything that followed this?
As it stands right now, there's one written contract from 1996 with Pelco Prince. As plaintiff is in his affidavit and complaint has testified, his employer changed in 2009, which would have been prior to his claims in this case, which statute of limitations for breach of contract and wage cases in the state is 6 years.
Are you answering my question?
So there's no prescription in the original agreement for oral modification. The affidavits and the record evidence submitted by defendants suggest that performance and oral agreement between the parties to modify the terms of that compensation structure. Plaintiff worked for the successor entity for 4 years, received over 100 pay stubs with the modified payment arrangement.
And do you maintain that the appellant was an employee or an employee at will?
I would submit that it's an employee at will. As I set forth in our brief, in the footnote, this contract, the 1996 one, which is unlimited in duration under New York law, considers those employments to be at will. And there's also New York law, which indicates that an employer in such instances can unilaterally.
So his 1996 contract had vacation days, sick days, holidays, and both the 1996 contract agreement, I'm just going to call it an agreement, and the later one, which is 2012, those both refer to him as employees, employee.
I believe Your Honor is referring to the Pelco HD subsequent sick leave policy agreement, which I think alone raises an issue of fact as to who plaintiff's employer was throughout the duration of his employment, which ended in 2017. But there is no indication in either of those as to the duration of his employment, and under New York law, that is considered an employee at will.
Thank you.
May it please the court, Your Honors. My name is Paul Bittner. I'm here with my colleague Alex Tillell, representing Centerfield Capital Partners in this case. Thank you for allowing me to appear today. We have a really straightforward issue. In our aspect of this case, Centerfield was added very late in the case. And when it was added, there was an amended complaint filed, but plaintiff did not file a summons. And so there's no record of a summons being filed or served. And under CPLR 304, a case is commenced upon the filings of a summons and complaint. So this case never commenced against Centerfield, and there's well-established case law in New York that holds that when a summons is failed to be filed, it renders the filing a nullity, and the Supreme Court would have no subject matter jurisdiction over the underlying action.
And we're beyond the 6-month statute of limitations?
6 years, Your Honor, yes.
Excuse me,
Yes.
6-year statute of
And,
limitations?
and so, in order to value judicial economy here in your time, I would say that the reason that we're here today is because it cannot be corrected the way it would ordinarily be corrected, which is to simply file a supplemental summons, or in a case where the motion court would grant our motion to dismiss us, and then a refiling could occur. That could happen, and that's what would probably have happened, but for the fact that in the interim, the statute of limitations against the claims, as we mentioned, 6 years for breach of contract and the related claims had run.
So you were served with the amended complaint?
Correct.
Naming your client as a party?
Correct.
And you answered that amended complaint, and in your answer, you did not raise any jurisdictional objections, right?
That's
Affirmative
correct.
defenses.
That's correct.
And so you're saying that despite the fact that you were served with an amended complaint and that you did answer that, the fact that they didn't file a summons in and of itself, everything else was a nullity with respect to your client.
Yes.
Therefore, the statute continues to run, it never ceases to run, and is now expired.
That's exactly right, Your Honor, and there is case law well established in New York that subject matter jurisdiction cannot be waived, and it can be raised at any time. And so, again, in situations where if the case had been prosecuted in a more diligent way or maybe more promptly, this could have been corrected, and we would have had to stand here with subject matter jurisdiction. But in this case, that didn't happen, and it may not be the best way to win a case, but my obligation to my client is to raise the legal defenses that we can. This court, the motion court correctly found that there was no subject matter jurisdiction in this case, dismissed it. That's a dismissal, not on the merits. It's just that now the statute's run, so it cannot be refiled.
Thank you.
Thank you.
Fifth Avenue Partners v. Punch House Flatiron. Yes.
Good afternoon. I'd like to reserve my time to answer questions first, and if there's time allotted, I'll add on to that.
You want him?
What, you represent your name and your
Oh, I
field?
apologize. Joseph Foley. I represent my wife and myself.
You're here pro se?
Yes, pro se, yes. I'd like to reserve my time for questions.
I don't know that we have any questions.
I don't know that we have it.
Why don't you start by telling us what your appeal is about?
Amazing. It's a one-line, illegible sentence with no reasoning or legal facts at all. This is about fraud. We haven't been heard ever. This is the first time in this entire process for 4 years that we've ever been heard. We hired an attorney who denied everything and didn't submit the documentation we gave him. We had to go pro se, and then we submitted reconsideration. That reconsideration was denied based off the fact that we didn't notarize our documentation. And since then, that notarization is gone, and we came to this court actually to appeal it and didn't know the process and didn't show up for oral arguments. In that process, I have lost so much, and so has my wife. We had a thriving business in fitness and have came back. We have a judgment that is astronomical, that makes 0 sense. We were there for 3 months with an email that allowed us to leave. The fabrications, I'm not asking you to judge this situation on the merits. I'm asking you to send this down to remain. If you want to vacate it, I'm not going to stop you, but the idea is that I would like a real reasoning why this happened. The affidavits in the below court are contradicting. The broker fees don't represent this LLC. We were allowed to leave December 1st and abide it, and the only thing that was left over was an amount, which we both agreed on, which was roughly $22,000 each, which was half of the security and half of what they wanted.
So how did the emails reflect any agreement that was reached between you and the landlord?
He threatened to sue us if we did not leave December 1st, and we agreed. And I countered with the fact that we will leave. He gave me till that Monday. I responded within the hour that we would leave December 1st. However,
But does that email state that if you do leave within a month or 2 months, you would be able to retain your security deposit?
no, that was not the case. It didn't say anything. It just said get out or you're, in simplest terms, I didn't memorize it, but
So what was the understanding? I mean, you're stating that that the landlord threatened you, but what was your understanding as to an agreement as to your vacating the premises?
leaving December 1st, and that in that interim, it was like Thanksgiving weekend, and the way he responded to multiple emails, it took 2 to 3 weeks.
Okay, so your understanding was that you would leave December 1,
Yes.
and then what rent would you be responsible for paying?
What rent?
Would you be responsible?
No, we would not. We would only have to pay $22,000.
Okay, so you would leave December 1 and you're paying $22,000. The $22,000, that's the security?
The security was 5 months, which was like almost $64,000.
So where does the $22,000 come from?
He came up with that number.
So your understanding was that if you left on December 1 and paid $22,000, that would be the end of the lease agreement and the good guy?
That was the offer, yes. And we said that we would leave when we like to discuss the amount because we didn't take occupancy till September.
Right.
And we were leaving December 1st for 3 months, and we did an entire build out for them, which they were going to be able to rent it out fast, which they did. That was the aspect.
So you wanted to negotiate the $22,000?
Essentially, yes. And
did the landlord agree to this?
He never responded, and he never responded again. It's just, I had no other choice but to leave. So
So you left December 1.
Yes.
Did you remit a check or monies to the landlord for $22,000?
No, I responded and asked him what he would like to do, and then we received 2 weeks later.
Sorry, could you say that again?
I responded and asked him what he wanted to do.
Yes.
And so he did not respond.
And then he served us 2 weeks later at my other location.
How many months of rent was that $22,000 for?
It was like a month and a half.
Month and a half.
Roughly, yeah.
And you had notified him when? At October?
We were in discussions because it was the second wave of COVID, and to not go into the merits of the case, but essentially they promised 3 things, which I don't want to go into, but basically scaffolding was going to come down because we were a luxury product. The second aspect, that the HVAC actually worked. However, they rerouted the HVAC condenser units to a different unit. And we're a group fitness where heat and condensation you have to move through. We couldn't have back-to-back classes or even execute. And with the combination, it's a family business, and we had that conversation. We thought this was. Everything changed with the one brother. That's the whole situation. The VJ was understanding everything going on. The other brother never met. I don't remember, I think it's Ryan, but essentially came to us, started putting different affidavits, which is contradictory to even VJ's affidavit. The question becomes is that I've laid this all out for the lower court, and that judge in the lower court is a very well-respected judge and has gave thorough response, especially with the first one, that you did not respond to these things, and we became pro se. The second part was I couldn't even make a decision based off the fact that there was no notarization for the affidavits. And then
How much is the landlord now claiming that you owe?
It was like $2 million plus, and it came down to $250,000, but with false information, which is basically the new lease, which started in April 1st. They said it's September. They said that we started our lease in June, but we really started in September.
Relative to the email.
Yes, ma'am.
Dated November 19th, which said, this is our offer. What is this? Landlord will retain security deposit of 4 months. You can send us a check for 2 months, and you vacate by, I don't see the date here right now, but did you comply with that? I know
We
you
complied with
rejected it.
we
Did you pay 2 months and agree that they could keep the security deposit of 4 so that it would be a total of 6?
No, what we agreed upon was leaving December 1st and having the discussion about the amount. He was able to keep the majority of the security deposit, which was half of the back, based off of the fact that we did renew and do construction on this place.
And that was based upon the November email?
The last November email, and then he didn't respond to calls, emails, and he gave me a timeline, And I kept calling, and there was no response because of the holiday, so we left. And then we said, do you have a check? What's going on? And nothing. And the fact remains is that we're talking about $250,000 of broker fees that don't even rely to this LLC. That's the biggest, that's like a fraud in itself. The second aspect is that the time frames, like even if you do the calculations, the simple calculations, when we took occupancy in September, even if you start till April 31st, which was the new lease of the new tenant, we left December 1st, the amount of rent and the security deposit that we paid covers all that. So, so do you understand?
So we're talking, you vacated in December, but did you
But
pay,
I'm also, but
did
I'm
you pay October and November?
Yes, we did.
So you didn't pay from December to April, right?
Which would have covered with the security deposit because we paid the first month's rent. We paid September, and then basically we were talking with him starting in October. I was like, hey, there's a wave that just happened.
So what was the monthly rent?
I think off the top of my head, it was like 12,000 or 13,000. That's why the 22,000 shaky on right this second. But it's roughly like a month and a half. Yeah.
Thank you.
You're welcome.
Good afternoon, Paul Gruber, Borough Goldstein, Altshuler, Naines, and Goydell, PC. This is the second appeal in this matter before the court. The first time around, Justice Leibowitz granted summary judgment against the respondent tenant and the respondent guarantors for approximately $250,000. There was a subsequent judgment for $25,000 in attorney's fees, which wasn't opposed by the guarantors. The guarantors then discharged counsel, and only they pursued an appeal to this court in a motion for renewal and re-argue. Pretty much everything that we've heard this afternoon was the subject of the first appeal. It's not properly reconsidered at this appeal.
When you say the first appeal, you mean before us or you mean?
Before this court. Before this court. Cited in the briefs.
So that was in 2024?
That is correct. This motion was made while the post-appeal motion practice in this court was going on. It was under 5015A3.
Well,
There's
they're now stating that there's new evidence.
Except that that evidence existed beforehand. They're talking about building department plans.
Right.
And as for a settlement, yes, there were negotiations, but there was never agreement. The affidavit of Ryan Mehta, who is one of the principals of the petitioner, plaintiff, makes that very plain. There was never an agreement. What we do have here, however, is a fairly stark email to me after this court affirmed its judgment saying, if you don't pay take my $25,000 offer. I shouldn't have mentioned the amount.
No, it's not in the record.
It doesn't matter, the amount. We're going to keep litigating and litigating and litigating this. Guess what? We're here. We're here.
So anything further?
And there's another motion before Judge Leibowitz right now that's still
I'm sorry?
hasn't decided. There's another motion also looking to vacate the judgment before Judge Leibowitz right now. Maybe it's more accurately worded as renew and re-argue the order that this court's hearing the appeal from today.
Anything further, counsel?
Nope. I think the brief's very clear here that that there's no reason for us to bite this apple to the core.
Thank you.
Thank you very much.
Anything further, Mr. Foley?
Yes, just really quickly. I am just trying to be heard for the first time on the merits. And he is correct. I was here. I was not physically here. I am trying to appeal this because it was not judged correctly. We're a family business in this city, very simply, at first. We listened to them in a very direct way, and they fabricated the truth, and we screwed up on the lease. However, that said, we admitted that. The problem in the end is the exit, post. But guess what? They fabricated the beginning, they fabricated the end. We're starting to see the repercussions of this. At the end of the day, I'm just asking for a justification to remain for full. And he is correct. There is more. I will try everything I can. That's my right to look as much as I can. I've given up so much to find out ways to just be heard. And that's all I'm asking to be, is to be remain down below for a full response. And that judge has the capability of doing it. That's all.
Thank you so much. Thank you both. Ramirez v. 255 West 108th Street, Corp.
May it please the court, Your Honors, John Shore for the plaintiff appellant.
while it is acknowledged that jury verdicts are not often reversed or overturned, this is a case clearly, respectfully, that warrants the reversal of this jury verdict. As a matter of law, certainly against the weight of the evidence.
So how is there no valid line of reasoning and permissible inference which could possibly lead rational persons to the conclusions reached by the jury on the basis of the evidence presented at trial?
Sure, Your Honor. My client fell, this is uncontroverted, 20 feet onto a metal platform. This is confirmed by witnesses, by photos, and
So we have conflicting expert testimony as to the result of the fall and therefore the plaintiff's resulted injuries, right?
at most, their experts would go to the amount of damages as it clearly, he fell 20 feet.
Counsel, why aren't the videos of, that were submitted, of the investigators' videos showing Mr. Ramirez doing normal activities, why isn't that something that works against you in this particular case?
Sure, Your Honor. That occurred many years later. That has nothing to do with causality. That would go to the degree of damages and to future damages, not to whether or not my client's injuries were a substantial factor from this 20-foot fall. He was taken by ambulance, and even though they quibbled about it, it's in the record. It's in the hospital record that he lost
Why would it not go to credibility? I mean, on the one hand, he is stating that he can no longer jog, he can no longer lift heavy objects, he can't carry heavy objects, he can't engage in normal activities. And then you have the video which shows him engaging in these activities, and I think like lifting a huge water bottle or something like that. But you have the video which totally, I won't even say contradicts, but is inconsistent with his deposition testimony as well as his trial testimony.
Well, again, Your Honor, this happened, this was a 2013 accident. This video was done 10 years later. It does not affect the fact that he fell 20 feet. He was unconscious.
This was just the trial on damages?
Correct, Your Honor.
And the only question that was submitted to the jury the jury answered was the accident of April 29, 2013 a substantial factor in causing the plaintiff's injuries, yes or no? And they answered the question no. I mean, they had the opportunity to look at the medical records, to hear the testimony from the experts, to look at the videos, and they answered the question no. Why would we disturb the jury's assessment of those factors?
Because it is beyond against the weight of the evidence, and it is irrational to not find a substantial factor when someone falls 20 feet.
Maybe they didn't think he had any injuries, period, based upon the way the videos displayed him.
The video, Your Honor, was taken 10 plus years later.
So, counsel, let me just say that I actually began to make a list of the inconsistencies. So, for example, on direct, he indicated loss of consciousness. On cross, he said he didn't hit his head. On direct, he said that the ladder rung broke while he was holding it. On cross, he said he had no memory of where his hands or feet were. On direct, he said he fell onto his coworker on his back. On cross, he said he landed on his feet. On direct, he said there was a small accident 3 years earlier. On cross, he said there was no prior accident, and Dr. Grimm indicated that he had said that he had hurt his neck in prior accident. So when my colleague asks, isn't this a basic question of credibility, end of story, I mean, the liability issue is not before us. The issue is damages, and there was a defendant's verdict. I mean, isn't it open and shut? The jury has heard, the jury has decided.
Your Honor, with respect to those minor inconsistencies, there's nothing that controverts that he fell 20 feet. It's in the hospital
But I think the
record.
problem-
There's nothing that, I'm sorry, Your Honor.
Go ahead.
Okay. As we know, when someone falls from a ladder, if there are minor inconsistencies, that does not change whether or not there was a violation. Here, whether or not he fell first onto a worker or then onto the platform, it's in the hospital record itself and the ambulance call report that he lost consciousness. The photo shows him face first without consciousness. That's the photo in the record. It also shows that he clearly fell 20 feet and he was taken to the hospital, and they did not find anything significant. They took CT scans. They took a CT scan and also
They did not find anything significant. So what I was going to say is, I think the issue is that what you term as minor inconsistencies, apparently the jury found to be real issues of credibility, and as my colleague stated, issues as to whether he did in fact sustain the injuries he's claiming he sustained as a result of this fall. So, but you have time on rebuttal.
Okay, thank you.
Thank you.
Good afternoon, Your Honor. Andrea Camacho for the respondent. As the court has pointed out, there's nothing irrational, unjust, untenable about this verdict.
Counsel, in addition to the inconsistencies that was just listed, there was also defense medical expert testimony that the plaintiff's condition was pre-existing degenerative, right? And pointing to evidence that there was no observable trauma on admission to the emergency room. So that's in addition to the inconsistencies.
Absolutely. It was plaintiff's theory that the herniations were acute. However, the hospital records found no clear injury. Our experts testified that the herniations were chronic. It took years. On cross-examination, although plaintiff elicited from his experts that the herniations were caused by the fall, on cross-examination, they admitted that there was chronic degenerative conditions in his back. So but most importantly, because this goes to the credibility issues, all of the experts stated the house of cards that plaintiff was trying to present was based upon, the foundation of that argument was plaintiff telling them that he had no prior problems with his neck or back. Without that basis, without that foundation, they could not give that opinion. And they admitted that on cross-examination. And there was no credibility for plaintiff. Because there weren't just some
Counsel, Dr. Grimm said that in addition to plaintiffs not telling him about his prior accident, Dr. Grimm also did not review the CT scans to compare impingement.
Didn't look at the hospital records at all.
And he didn't look at the ER records either. Yeah.
Maybe there was a lot of issues with regard to Dr. Grimm and Dr. Kaplan. Plaintiff was referred to that after by Goriev's office, and there were inconsistencies in that chart, and they weren't sure if he was shown them or not, but they weren't in his records. He didn't review them in preparation for his trial testimony, so he wasn't sure and couldn't attest to whether or not he saw them.
Fair.
So counsel, this was a trial on damages. And the plaintiff testified as to what he felt, and he presented his witnesses.
Correct.
And the defense cross-examined the plaintiff and presented their witnesses and their evidence.
Correct.
And then the jury made a determination.
In less than 3 hours.
Why should we overturn that determination?
There's absolutely no basis for it. I'll sit down.
Thank you.
Very quickly, first of all, with respect to the prior injury, whether or not there was some confusion, and then there was some testimony that he missed a few days of work. He never had any treatment at all. They had all the opportunity to look for that and search that out. There was no treatment. He worked 7 years for Jade Construction with no problems. And this isn't coming from Kaplan and Grimm and Brisson, Your Honor. This is coming from the St. Luke's record that immediately when he fell, they diagnosed him as having numbness in the arm and the leg, which is indicative of a radiculopathy with respect to the arm for a neck radiculopathy. And with respect to the leg, that's a lower back radiculopathy, which ultimately necessitated
Counsel,
the fusions.
I'm going to ask you the same questions that I asked
Sure, Your Honor.
your adversary. The jury heard the witnesses and weighed and made a credibility determination. Who do they believe? Do they believe the plaintiff's witnesses in terms of experts and the defendant? So it's a battle of the experts. They heard all that, they looked at the video, and then they came to their conclusion. And their conclusion was that whatever your client said he sustained was not causally related to the accident. Whatever injury he claims he has, not causally related to the accident. And that was the end of the deliberations, correct?
Correct, Your Honor.
So why should we go behind what the jury was presented and make our own credibility findings?
Absolutely, Your Honor. If this was an issue about Mr. Ramirez is appealing the amount of damages and asking for additive that the jury gave an insufficient award, that would be another story because those.
Then we can look at that. But here they determined that there was nothing.
But this is where the heart of the whole case is on causality. When my client fell 20 feet and the hospital records that were taken and noted when he fell 20
Did he
feet,
Did he fracture any bone in his body?
Page 628 of the record, Dr. Kolb said, and there was nothing to controvert that it is very uncommon for anyone to fracture.
No, but my question was there anything in there, an x-ray, that says he's got a fractured ankle, he's got a fractured arm or hand, anything?
Or just to add to that, the emergency room records, was there anything to show that when he presented at the emergency room that there were any injuries induced by trauma? A trauma that literally just occurred?
The only thing they were looking for with a CT scan, because they took the MRI, Your Honor, which is the gold standard to show herniations, was to see if there was any fracture. It was noted.
We're looking for a brain bleed, right?
Yeah, but they're looking for numerous things. I mean, he comes in and states that he fell from a certain height. They're going to be looking for numerous things, and they found nothing.
This is not the case where there was no treatment, there was no witness, and then 3 weeks later, someone is saying, you know, I'm complaining about back or neck pain. This is a case where the EMS came, immobilized him, and noted trauma. He fell 20 feet, and they noted, this was noted in the hospital.
I don't know how many times you've stated that he fell 20 feet. I mean, that's not the issue. The issue is damages. Liability was not the issue. The issue was damages.
No, respectfully, Your Honor, I understand that, but the issue is causation here, and it's inconceivable that someone who falls 20 feet, and even the hospital records, when I said it did not, the CT scans showed minimal degeneration. This isn't coming from Kolb or Kaplan or Brisson, who actually, Brisson and Kaplan are the only active surgeons. The only surgeon they had is someone who hasn't practiced in 5 years.
No, I understand all that, but that's not, the issue is, and our determination is whether or not the jury's verdict, which was a defense verdict, was so, out of the realm of possibility, was not based upon the evidence or lack of evidence. That's all we're here to consider. I may feel, yeah, you know what, you fall 20 feet, I'm thinking you're going to have a fracture or what have you. You certainly believe so as well. But again, the jury made a determination, and so the question is whether or not we, should in fact, use our judgment, impose our judgment for that of the jury.
When someone falls 20 feet and are taken to the hospital, and all the symptoms that ultimately necessitated the medical treatment, such as numbness in the leg and the arm, which is clearly indicative of a radiculopathy. He was complaining immediately of cervical pain and low back pain. That's why they did the CT scans. And Dr. Kolb, no one controverted that it's uncommon for someone to fracture
It is.
a
Thank you so
vertebrae.
much.
Thank you, Your
both.
Honor.
De Silva v. Super P57. Whenever you're ready.
Good afternoon, Your Honor. May it please the court. My name is Michael Joseph. I'm an attorney with Cohen and Dyckman. We represent the defendants' appellants, cross-respondents in this matter. And to that end, the defendants' appellants are requesting that the court vacate the award of summary judgment to plaintiff respondents on their labor law 240 claim and modify the motion court's order so as to award it to defendants' appellants. Your Honors, this presents a classic quintessential example of a recalcitrant worker.
How?
Your Honor, 15 minutes before the incident, the site safety supervisor, Paul Frieda, was walking along the site and noticed plaintiff and his co-workers standing atop structural steel members, at which point he summoned plaintiff specifically.
Was there a directive by the supervisor to use any particular equipment, to use the scissor lift or anything of that nature?
Yes, there was, Your Honor.
There was a direct?
There was a direct order to use the scissor lift. Mr. Frieda testified on page 5.
How close is the scissor lift to the actual surface of the building? Because there's testimony that the reach of a human being would not extend safely from the scissor lift to the work.
Well, there's 2 points I'll raise to that. One, when Mr. Frieda called plaintiff down, plaintiff descended to Mr. Frieda's location on the ground floor by way of the scissor lift. And that's in Mr. Frieda's testimony.
That's not the same thing, counsel.
I
Rising up is not the same as doing the work.
No, Your Honor, I'm saying that he was able to descend from the structural steel member down on the scissor lift, which is located right next to the building. And in terms of doing the work, there's also testimony on the record from the Hunter Roberts assistant superintendent, Christian Miller, along with Mr. Frieda, both of whom said that the scissor lift could have been used to do the work.
So, I know I was the one who mentioned the scissor lift, but did you raise that below?
Yes, Your Honor, we did.
You did?
It's also further evidenced by the fact that plaintiffs opposed it in their expert affidavit to mention it as well. So even if it wasn't, raised below, which it was on page 40 and 41 of the record, it would still be suffice to preclude summary judgment to plaintiff, as that's an issue of fact that they would have to eliminate.
Wasn't it in use?
I'm sorry?
Wasn't it in use at the time and thus unavailable?
Your Honor, Mr. Frieda testified that he spoke to plaintiff and issued this directive to him 15 minutes before the incident. And plaintiff descended by way of the scissor lift. So it could not have been in use by others at that time. At minimum, there's an issue of fact on that. But notwithstanding that, both plaintiff and his union shop steward, Dave Thompson, testified that there were multiple scissor lifts at the site. So if there was one in use in the 15 minutes after the fact, then he simply could have requested another one for use.
Was there anything in the record that he was aware of the presence of the scissor lift?
Yes, Mr. Thompson testified, and he also testified that if he needed any equipment, he could ask Mr. Thompson, who would then go to Goebel's foreman to procure it.
How about Mr. Thompson said that they could not use the scissor lift because they would not be able to reach the facade of the building by using the scissor lift. They could possibly use some other type of boom lift if they had one, but since they didn't have one, the only way for them to reach the facade at that particular point was to do what they did. Put up the plank, get up on it, and do their job.
Your Honor, this is an exact same issue of fact that was raised in Quinones, where The plaintiff testified that he couldn't use a piece of equipment, but the assistant vice president in Quinones testified that it was possible to use the equipment that was at issue and that was readily available.
That's an awfully big generalization, don't you think? You have an expert witness who testified that a properly placed plank is a suitable working platform that does not require to be tied down. That is beyond, I mean, I read
Your
that
Honor,
and I
this-
said, you've got to be joking.
Your Honor, this isn't a piece of wooden shielding or planking. This is an OSHA plank. It's a specially
I'm
designed.
sorry, a what plank?
An OSHA plank.
OSHA plank.
Yes, it's an OSHA plank. It's not designed to move. The only way that this moves, and this is by plaintiff's own concession in his own testimony, is that if you step on the edge overhanging, it's similar to how a seesaw.
And you have the expert testimony of the plaintiff's engineer who says that it was dangerous to reach from the scissor lift. There were no railings on this. Essentially, the other side says this was an informal scaffold.
And I think when we're looking at the 240 sub 1 cases, it's the adequacy of whatever device that's being given.
Does your expert state that the scissor lift would have been the proper, equipment, or would have allowed the workers to actually the ability to perform their work?
The testimony that the workers were allowed to be, where the scissor lift was adequate for the performance of the work comes from the
So your expert states that they would have been able
Our
to...
experts focused on the planking that was actually used.
Thank you.
Good afternoon, Your Honors. May it please the court. Lisa Como for the plaintiff, respondent, and appellant. The defendants took the position below. They're really raising the scissor lift issue for the first time on appeal. We've addressed it because it doesn't matter.
Well, it was in the expert's report, right?
He mentioned that the scissor lift existed. It was in plaintiff's expert report where he put the schematic and the specifications for the scissor lift based on the make and model. He explained why what Mr. Thompson, the supervisor, said was true, which was that without an articulating boom, you couldn't get close enough. The
So
reason
was there
is
anything in the record that your client was actually directed to use the scissor lift?
Not at all. Well, sorry, let me back up. There's testimony from Mr. Frieda that he thought that they should be using the scissor lift and that he instructed them to use the scissor lift.
And
However, it's not feasible.
Do not stand on the steel. I told you not to stand on the steel.
Right.
That was part of his testimony.
Not stand on the steel. And that's actually what Mr. Thompson said, is that, well, that's why we put the plank. Mr. Frieda denies that he was the person who told them to use the plank, but Mr. Thompson said that there was a safety guy. Maybe it wasn't Mr. Frieda because there were multiple, but he said, yeah, he told us to use the plank. And Mr. Thompson was also very clear that it was their custom and practice, not intentionally, not to tie the plank down because they needed to move it. That was what they wanted to do. And with respect to the scissor lift, again, it's such a red herring because we addressed it on our own motion, which was filed simultaneously. We did not initially put in our expert affidavit in response to any arguments they made about a scissor lift.
The plaintiff was harnessed, right? But the harness was tied
at his feet.
At his feet.
Yeah.
And there was a
absolutely
reason
useless.
for that because there wasn't anything above him
Right.
to tie up to
And
create
that's-
tension in the lanyard.
Right, it's undisputed. There was no overhead anchor point, so he tied to the only thing that he could tie to. And so,
The distance was insufficient, correct?
yes, it was insufficient
In other
to
words,
arrest
if
his
falling off would not stop him.
Right, it
from
would not
hitting.
arrest his fall, which I will now just slip in, if I may, my Industrial Code 23-1.16 argument. I think that it's clearly, it's not only logical, but totally supported by the case law and by our expert opinion, when it says in 23-1.16D that you have to be tied off no lower than 2 feet above the working surface. Implicit and inherent in that is that you also have to be tied off such that you don't strike the level below. You know, you can say, oh, well, I was tied off 2 feet above and I still hit the level below. That's not, you know, the expert opined that implicitly that's not sufficient. And I think that's a very logical and appropriate legal interpretation under that regulation. We also allege 5.2, which is the prohibition against using a scaffold, which is defined as a working platform, and we detail in the brief. You're prohibited against using something that's not approved by Section 5.2. This plank, which they were using essentially in place of a scaffold or other suitable elevated working
Was
surface.
8 inches wide.
Yeah, it's completely unsuitable. Even the defense witnesses, they never contended that this was
Some
a safe
people's
working
feet are
surface.
longer than 8 inches.
I think mine might be.
Thank you very much.
Thank you.
Judge, to quickly, Your Honors, to quickly address the points of contention with respect to Labor Law 241-6, under 23.1.16D, there's no statutory trigger for compliance. That's in a separate industrial code provision that wasn't alleged by plaintiffs in their bill in particular, so that's improperly raised for the first time on appeal. With respect to 5.2, there's a decision in the Fourth Department that analyzes an identical provision of the industrial code using the exact same language just pertaining to excavation. And that provision has been deemed to be insufficiently specific to give rise to Labor Law 241-6 liability. So applying the statutory tenets of interpretation to this provision here, which has no interpretation as of yet, this would also be insufficiently specific as it employs the exact same language. With respect to the site safety guy that she's mentioning, this was clarified in plaintiff's testimony and Mr. Thompson's testimony as being Global's foreman, and not actually a site safety guy that was employed by PSS or any of the defendants. So with respect, and finally, with respect to the scissor lift and the planking issue, there's no requirement under OSHA that the plank be tied down, but nonetheless, there were ropes that were available at the site, and that earlier that morning, Mr. Thompson testified in a sworn affidavit that he directed them, hey, if you need ropes or anything to secure the plank down so it doesn't move, they're in the shanty, and you should use them. Plaintiff didn't use them. And the reason that they didn't use them...
Is that because they weren't there? Are you saying that he didn't use a tie-off? He didn't have a place to, what is it called, an anchor point?
There's two different things. There's ropes that would tie the plank to secure the plank or tie the plank to the structural steel members. And then what I think you're describing is a lanyard, which would be secured to something else to prevent a fall. The ropes and clamps for the OSHA planks were in the shanty, and plaintiff was advised that morning that he could use them to tie them down. Mr. Thompson testified that they had a custom and practice that they typically didn't use them because it would be inconvenient since they would have to move the plank backward and forth horizontally to access different levels.
Thank you. Last case for argument is Coast Marine Company v. Holland and Knight. Yes, you may proceed.
Good afternoon, Your Honors. My name is Tricia Rich. I'm an attorney at Holland & Knight, and I'm here today for the respondents, appellants, Holland & Knight LLP and Michael Frivola. We are here today due to a very fundamental misunderstanding of not only the conflicts principles that underlie the attorney-client relationship, an attorney's relationship with his or her client, but also a misapplication of those very principles. There are two independent and dispositive errors made in the lower court below, each of which independently would require reversal here. First of all, the court, as you read in our papers, disregarded the corporate separateness of the 5 entities that are at play here and rewrote the engagement letter, collapsed those entities, and treated them as one without any evidentiary findings at all.
So Blumenthal Asia is one entity, Blumenthal Germany is another, Stigma is one entity, and Coast Marine is another. So you have 4 entities right there.
Correct, and another Blumenthal entity on top.
On top.
Right.
And they all have sort of like the same email ending, blue something.
There are similar email endings at issue in this case. The record does not indicate one way or another whether or not all entities across the entire Blumenthal universe uses the same email endings.
So
But yeah,
Holland and Knight had an attorney-client relationship with Blumenthal Asia. Is that correct?
Holland and Knight had a attorney-client relationship with Stigma.
Stigma.
And Stigma was managed at the time by Blumenthal Asia.
Right.
Correct. At the time that Holland and Knight entered into the attorney-client relationship with Stigma.
How did the agreement, that attorney-client agreement with Stigma, how did it reference any other entities that might be related to Stigma?
Sure, we have language in our, like many large law firms, language, very specific language in the engagement letter that says our attorney-client relationship is with you, Stigma. Our attorney-client relationship, our obligations go to you, Stigma. We do not represent any other corporate affiliates, subsidiaries, any other people other than you, Stigma. You are our client.
Including any parent company, sort of like Blumenthal?
Correct. That language is clear in the engagement letter and was completely disregarded by the lower court.
And in order to have an attorney-client relationship, I'm looking at the language from the engagement letter, any such representation will be the subject of a separate engagement letter.
Correct, and that never happened here.
So the court found that because there was, Holland and Knight had a attorney-client relationship with Stigma, therefore they also had an attorney-client relationship with Blumenthal Asia.
Correct, but not just Blumenthal.
And also Blumenthal,
correct.
Germany as well.
All
five right.
entities. And I want to make really one very important point. We think that's wrong, but even if it's not wrong, there's no dispute at all that Stigma and those entities are a former client of Holland and Knight's, right? And so what that means is the court misunderstands. When you read the court's language, what the court says is, I find this is a former client, so there's a concurrent conflict of interest. Former clients are Rule 1.9. Concurrent clients come up under Rule 1.7. So if the court is saying it's a former client, there's no such thing as a concurrent conflict of interest. That's a 1.7 conflict. So it doesn't matter. It's not an issue of whether or not, in that instance, Coast Marine would have carte blanche to disqualify Holland and Knight. It wouldn't. What would happen then is we would have to look to Rule 1.9 and figure out if the underlying matters were substantially related. And the thing we're trying to control for is confidential information, right? And here, the court, it's like a complex spaghetti at a wall, and they completely disregard, they treat Mr. Frivola's conflict like it's a 1.8 conflict instead of a 1.10 conflict that was imputed to me, Mr. Frivola, and every other lawyer at my firm. Then they set that aside. They tell us we have a concurrent conflict with a former client, which is not a thing that exists in the world of conflicts, and that is used to disqualify us, and that waiver doesn't matter. There are so many material errors. This decision must be reversed.
Thank you.
Good afternoon, Your Honors. My name is Jeremy Shockett. I represent the respondent. I just want to point out one really important point. The judge below did not do what appellant says. The judge below did not say, just because you represent Stigma, then you must represent Blumenthal. The judge actually made findings and said, irrespective of the retainer agreement, Blumenthal and Holland and Knight formed an attorney-client relationship. And in their brief, they write, you should look to the words and actions of the parties to see if the attorney-client relationship.
Even if we were to say that this was with Blumenthal Asia, which was the manager, how does that then extend to Blumenthal Germany or Blumenthal?
So Blumenthal Asia and Blumenthal Germany, the court found below, were actually basically working together and working as one.
Based on what? That's what I could not understand. How was this determination made? Based on what
So
record?
the Blumenthal Asia and the Blumenthal Germany legal team all spoke from the same email addresses. They're the same people. So yes, at one point, Blumenthal Asia.
But is that sufficient to go where you need to go for those purposes? Would you need to show more than just similar email addresses?
It's not just similar email addresses, it's one of the issues. The other issue is it's the same actual people. So when Holland and Knight, Mr. Frivola, is communicating with Blumenthal, he's not just communicating with an email address, he's communicating with individual people at Blumenthal. And I have to remind the court of something that my adversary has really never addressed. Mr. Frivola at the arbitration hearing almost a year ago said on the record, Blumenthal was my client. And he was saying it in the sense of, well, he's not my client today, he's my former client. He admitted he was the client. The court just was asking my adversary questions about concurrent and former clients. The former client issue only happens because the stigma matter ends at some point.
So how come you brought this up at the last minute?
Hold.
How come you delayed 2 years in moving to disqualify Holland and Knight? How come this objection was raised on the actual morning of the arbitration? People were asleep.
No. Here, and that's a great question. And it was raised below, and the judge made factual findings on it. And the answer is because Mr. Frivola purposefully, I don't know if it was nefariously, but purposely never revealed his existence in litigation to Coast Marine.
But the firm Holland and Knight had appeared.
Correct.
And so he's a member of the firm.
Correct.
So if the firm is appearing and Mr. Frivola would have a conflict, wouldn't that conflict be imputed to the firm?
It should be imputed to the firm. And the problem
Or
is...
wouldn't that alert you that Holland and Knight is now here?
So that's a reasonable question, and I don't begrudge you for the question. The issue, though, is we're turning it on its head. We're saying it's up to the client to know all of the conflicts. The lawyers in this matter, their conflict waiver in their retainer agreement says a blanket waiver. If there's a conflict, we're going to alert you to what the conflict is. We're going to disclose it. We're going to talk about it. You can get independent counsel, and you can...
But let's talk about the engagement letter. The engagement letter is written tightly. I mean, it is so clear as to what it says. You are our client. You are our client for this reason only. Nobody else but you and I.
I agree with you. At the moment it was written, I'm sure that was the intent. However, actions can change things. We all know the joke. You don't need $1 to actually form an attorney-client relationship. You actually don't even need a written retainer agreement. What happens is, after that retainer agreement is signed, Holland and Knight forms an attorney-client relationship with Blumenthal. And just because it's not written down, Holland and Knight shouldn't get the benefit of saying, okay, we're getting all the benefits. We're getting paid by Blumenthal. We're getting strategic advice from Blumenthal. We're talking to Blumenthal. They're controlling the litigation. But no, they're not really the client because we have this engagement letter which says it's only stigma. That they can't have their cake and eat it too.
But take a look at the inverse or reverse, whatever it is. You're saying, oh, they have the same email and they have the same people. And they're not talking to each other, and what? They don't know anything about what's going on? You're saying they're all related.
So I am absolutely saying they're all related, and I'm saying that the court below made findings, and frankly, my adversary never, ever explains why their attorney said on the record, Blumenthal was my client. They never explained it to this court. They never explained it to the court below. After being given opportunity, there's nothing. Mr. Frivola filed an affidavit. He never mentioned the remark, even though it was in our papers to start. That to me is it. The actions and words of the lawyers say, I believed Blumenthal was my client.
Thank you.
Thank you.
So why don't you pick up there? Is that correct? Was that statement made?
Sure, yes. I have 4 quick points, but I'll start with that one. Yes, Mr. Frivola did say that in the heat of a moment, deer caught in headlights, on the morning of trial when Holland and Knight was the subject of the motion to disqualify for the first time. 2 points about that. Number one, Mr. Frivola's errant statement does not control the law or the documents in this case. Number two, even if Mr. Frivola is right, and even if the trial court is right on the first issue, that we should collapse all of those corporate entities and give Blumenthal the benefit of both sides of its corporate separatistness, even if that's right, it still makes Blumenthal a former client. We still have to look to 1.9 and see if the underlying matters are substantially related. And the trial court erred when it did that too. Instead of looking at whether or not the matters were substantially related, it looked at whether or not the entities were substantially related.
Are the matters substantially related?
It's not in the record, but we would say no. We touch on it in our briefing. A couple of other just quick points I'd like to make. Number one, the case law cited on the informal formation of an attorney-client relationship is when there's no engagement letter and not when there's an engagement letter in place that clearly spells out.
Well, I mean, I thought that was interesting because your friend stated that it was the actions, although there was not a formal retainer agreement, that there were the actions. They were acting as their attorneys.
Right, but that would, again, fly in the face of the conflict letter. Payment by a third party is not enough to form an attorney-client.
What about the fact that it's the same, according to your friend, it's the same individuals, the same email?
There would have had to be, testimony and evidence taken on that issue. There wasn't here. But even if that is correct, it still puts us in former client land, right? It still is the 1.9 analysis. We know here the client was on notice because the client reached out to Mr. Frivola 6 months into the representation and almost 2.5 years before they moved to disqualify. They knew he was at Holland and Knight and they asked him to get involved. And finally, even if we set aside all the corporate irregularities, there's no way this is not waived. All of the case law says you can't wait until the eve of trial. Here, they waited to the day of trial, 2.5 years after they first reached out to Mr. Frivola, 3 years after Holland and Knight, 35 months after Holland and Knight filed its appearance. That, under the law in this state, is waiver. Thank you very much.
Good seeing you, Mr. Good seeing you, Mr. Shockett. Take care. Oh my God.
Thank you so much.
I did my last murder trial in front of Judge Weber.
You got off.
What?
And you got off.
Yeah. The